Good morning, everyone. Good morning, Advocate Chauke.
Morning, Chair.
Good morning, Advocate Mayet.
Good morning.
You ready?
We are ready to proceed.
Advocate Chauke, you continue to be under oath.
Thank you, Chair. Confirm.
You may proceed, Counsel.
Thank you, Madam Chair. Chair, in light of the panel's concern at the adjournment yesterday regarding the interpretation of Clause 3.1.2 of the Terms of Reference and the interpretation which could potentially give rise to some confusion, I seek to address this position before proceeding further with cross-examination of Mr. Chauke. And with your leave and guidance, I will proceed. As the panel is aware, Clause 3.1.2, as presently framed, has two possible interpretations: a narrow construction, which is confined to the decision made on the 2nd of February 2012 and the subsequent decision made in April 2014. And there's a competing interpretation which gives a broader construction which extends to the subsequent conduct and delay. After being advised by the panel and reading through the transcripts extensively and considering the position, it is evident that Advocate Ngcukaitobi herself accepted that both interpretations are tenable. And she further indicated that to the extent that a broader construction is intended, this may require an amendment of the terms of reference. I understand that such amendment is pending and the scope of the clause is not settled. This leads me to a bit of a conundrum because if the clause is to be interpreted narrowly and we confine it, then the scope for meaningful cross-examination on that issue is significantly constrained. And this is simply because the Supreme Court of Appeal has already determined that Mr. Chauke's decision was not irrational. And in those circumstances, the core evaluative question in relation to that decision, the decision of the 2nd of February 2012 and the April decision in 2014, the Supreme Court of Appeal has settled that. So cross-examination directed at undermining the Supreme Court of Appeal would risk, it does not make legal sense. By contrast, if the clause is to be understood or amended to extend the consequences of that to the consequences of that decision, including the alleged delay in proceeding, then there is clear and proper field for additional cross-examination. However, as evidence leader, my duty is to ensure that the evidence is fairly and properly tested within the bounds of the issues before the panel. And as of yesterday, I was of the view that both the limited as well as the extended wide interpretation is necessary to be canvassed. However, in the absence of clarity, there is a real risk that continued cross-examination may either exceed the scope of the terms of reference or proceed on an interpretation of the terms of reference that is ultimately not adopted. And that would be unfair to the witness and unhelpful to the panel. In these circumstances, I respectfully submit that it would be preferable for the scope of the terms of reference 3.1.2 to be clarified or necessarily amended before cross-examination proceeds further on that aspect. In those circumstances, and reserving the right to recall and cross-examination, those would be my submissions on that aspect.
Thank you, Counsel. You are aware that the terms of reference constitute a charge or charges against Advocate Chauke, correct?
Yes, Madam Chair.
He is called to answer the terms of reference as they are. And nothing can be implied on these terms without a proper amendment. I think this is a very basic principle in criminal law. We are not in a criminal law zone, but we have to bear in mind the prejudice that may emerge from a broader interpretation. If you are inclined to do that, as was suggested by Advocate Batoyi, an amendment was sought in a substantive application. We made a ruling and recommended to the President that there is no merit in the application, but of course, the power to amend the terms of reference reside with the President. If he decides to amend the terms of reference, then so the terms will be amended, then you can then proceed on the basis of the amended terms. Without the amendment, we have to proceed on the basis of the terms of reference as they stand. This is our view, and we suggest that you reserve your right to further cross-examine Advocate Chauke in the event the President decides to amend the terms of reference. My sister, I would like to verify one aspect with you.
Yes, thank you, Chair. Advocate Mayet, when you addressed us about this, you also mentioned that acting on the advice of the panel, amongst others, you have decided to maybe take the step that you are taking. What is it correct, or I have misunderstood?
I must apologize. I used the incorrect term.
Yeah.
I did not mean acting on the. I meant as arising of as a result of the questions that were posed to me yesterday. You will recall that the judge advised me to traverse the transcripts and to highlight the portions, specifically where Advocate Batoyi makes these material concessions regarding the interpretation. I was simply referring to that.
Okay, when you said advice, you did not mean that you have been advised by us. The advice was for you to look at the record, satisfy yourself on what steps to take in regard the facts that are already before the record. So are you saying you have satisfied yourself and you have then opted to take the option that you are now exercising?
Indeed.
Thank you, Chair.
Yes, the further aspect, thank you. The further aspect relates to 3.2.2.3. You would have read the transcript. My sister is helpful in that regard. She is bringing to my attention that which transpired on the 27th of November 2027, when Advocate Batoyi was on the witness stand, I asked her some questions, and then she conceded that in relation to that clause, that term, the discontinuation of the criminal proceedings, as reflected in term of reference 3.2.2.3, that clause means it refers to the withdrawal of the matter prior to the referral for inquest. That being the case, it doesn't appear to me that we can proceed also with your line of questioning as you did yesterday in relation also to term of reference 3.1.2. That is open code, the failure to continue with the charges. I think these two clauses can be read together, and without an amendment, it doesn't seem to serve any purpose to call witnesses to testify about which the SCA has pronounced upon. Some of these matters are matters for argument. We can deal with them later when you file submissions. That said, you may proceed with your cross-examination.
Thank you, Judge. In light of my submissions, I reserve the right to further cross-examine Mr. Chauke in the event that the clause is amended, but at this point, I have no further questions.
Yes, thank you, Counsel. Advocate Ngcukaitobi, re-examination.
Madam Chair, I'm not sure what the plan of the evidence leaders is, because Mr. Mhlamunyane had stood down yesterday to work out whether he wants to put any further points on the questions that arose at the end of his cross-examination yesterday. But I don't see that he is in the room at the moment. But if there's nothing further, I'm happy to re-examine.
Yes, let us wait for Advocate Mhlamunyane. Advocate Mtsweni, do you have an idea?
Madam Chair, if I could just clarify, he is available. If we could just take a 5-minute adjournment to rearrange seating. He will.
Well, we cannot take an adjournment because I cannot walk up and about.
If I could
because
just
a strain on my leg. We will sit here and wait to adjourn at an appropriate moment for tea. For now, send someone to call Advocate Mhlamunyane, because he had the afternoon and the evening. We should be here to proceed with that aspect of cross-examination. Advocate Mhlamunyane,
Thanks, Madam
we
Chair.
asked that you be called because when we adjourned yesterday, you reserved your right to further cross-examine the witness in relation to certain aspects that you raised. Advocate Mayet has completed her cross-examination, also conditionally, and it is your chance to proceed now with the further questions to the witness before Advocate Ngcukaitobi re-examine the witness.
Thank you, Madam Chair.
Mind us just to recap on which aspect you had to be given a chance to reflect and further cross-examine the witness. Do you remember?
Yeah, I remember that we were dealing with signatures that were appended, documents that where some of them were signed by Advocate Chauke, and then it emerged that the issue was extensively dealt with during cross-examination of Advocate Maema by Advocate Mtsweni, and Madam Chair urged me to read the record. I've indeed read the record, and Advocate Mtsweni dealt extensively with that issue. I will not deal extensively with the issue. I have about 2 or 3 questions, but it was illuminating for me to go through that record. There is one aspect that I picked up, but in the course of my cross-examination, I will refer to it. And Madam Chair indicated to me that we should show where Advocate Chauke has taken a prosecutorial decision. Now, let me begin by referring you, Advocate Chauke. Good morning, Advocate Chauke.
Morning, sir.
In other words, demonstrate to us on this record the evidence that shows that Advocate Chauke took a prosecutorial decision. Remember, and I must emphasize that, remember this is a racketeering issue, which is a matter of legislation. In terms of the law, the Act, POCA, only the NDPP is seized with the power to issue certain decisions regarding to racketeering. So bear that in mind when you point to that evidence regarding the prosecutorial decisions insofar as Katomena is concerned.
Thank you, Madam Chair. I will bear that in mind. Let me begin, Advocate Chauke, to refer you to Bundle LO3, and the page is 00866.
be helpful if you call it what it is.
It
Legal
is-
Opinions, Volume 3, and then refer to the pages.
It is LO3
Thank you.
where Advocate Jiba's answering affidavit appears. It starts there. In the matter of the General Counsel of the Bar of South Africa, this is Advocate Jiba and others. So it's 866. This was a matter in which the GCP was applying for the striking off of Advocate Jiba's name from the roll of advocates. Now, let me begin by referring you to page 00868 and specifically go to paragraph 201, which
Yes,
you are there,
Yes.
which I propose to read into the record. It says, this matter involved an application to review and set aside the decision taken by me to issue the authorizations necessary to prosecute Boysen in terms of poker. Boysen was charged with 7 counts, only 2 of which were poker related and therefore required written authorizations. On 17 August 2012, I approved the applications for authorizations in terms of Section 2.4 of poker in respect of contraventions by Boysen of inter alia Sections 2.1e and f of poker. These charges related to racketeering offenses. Boysen was, however, also charged with other offenses, including 2 counts of murder, 1 count of unlawful possession of a firearm, 1 count of the unlawful possession of ammunition, and defeating or obstructing the course of justice, unquote. Now, you will agree, Advocate Chauke, that it is common cause that on the 17th of August, 2012, Advocate Jiba issued the poker authorizations,
Yes.
Section 2.4. Now go to paragraph 210, which you'll find on page LO00871. This paragraph is already on record. It was read into the record during the testimony of Advocate Patohi, but I propose that for purposes of completeness, to read it again into the record so that we can put it into its proper context. It says, following the consultation, the prosecution team agreed that Advocate Chauke, as the DPP in charge of this matter, would be the liaison person between Advocate Waters SC team and the prosecution team, and would provide the Waters SC team with all the facts and evidence in the dockets necessary from the prosecution team to prepare an answering affidavit to be deposed to by myself on behalf of the NPA. I refer the court to the confirmatory affidavit of Advocate Chauke filed herewith. Now, an issue arose as to which matter was being referred to. You will agree that this matter that is being referred to in paragraph 210 is the Boysen matter, the review Boysen matter. Not so?
Yes.
Now, paragraph 211 says that the holders team then prepared the answering affidavit, which was finalized by Advocate Chauke and which I signed. You agree you finalized it?
Yes.
You can only finalize an affidavit if you are intimate with the facts.
Yes.
Not so, Advocate Chauke?
Yes.
And Advocate Jiba says you were in charge of the matter.
Yes.
And read that sentence further. Don't just focus on the words. Read it in the context in which it is.
Paragraph 211.
Yeah, 210.
210.
Because you say, Advocate Chauke, according to Advocate Jiba, was in charge of the matter. And the answer is yes. And I'm saying to you, do not focus only to those words. In paragraph 10, I think you have to read it in its context. Read further.
Advocate Chauke, as a DPP in charge of this matter, would be the liaison person between Advocate Warders SC team and the prosecution team, and would provide the Warders team SC with all the facts and evidence in the dockets necessary from the prosecution team to prepare an answering affidavit to be deposed to by myself on behalf of the NPA.
Before you proceed, Counsel, you are correct that this part of the record was dealt with during the testimony of Advocate Batoi. Actually, these paragraphs were read into the record, if you remember. And her focus was in those words that Advocate Chauke was in charge of this matter. This was with the view to support her proposition that Advocate Chauke was just not a mere coordinator. So just bear that in mind.
I will, Madam Chair.
Proceed.
Go to LO2, Advocate Chauke. Bundle LO2. And specifically on page 00297. This is an application for a POCA certificate. Do you see that?
Yes.
It has been extensively dealt with by Advocate Mtsweni when he was cross-examining Advocate Maema.
Yes.
It's in your name,
Yes.
but it's unsigned, and it's dated 10 July
Yes.
2012.
Yes.
And it says here in paragraph 2, I've perused the document and recommend the application.
Yes.
And it was prepared according to Advocate Maema by Advocate Maema.
Yes.
Go to LO3.
Councillor, I don't want to interrupt you, but I need to understand whether you are connecting the contents of paragraphs 210, 211, and this part of LO3 that you've just referred to?
Yes, I'm connecting them, Madam Chair.
Yes, thank you. And in LO3 00297, you referred the witness to paragraph 2
Yes, paragraph 2, Madam Chair.
only.
Only.
Thank you. Proceed.
Go to page LO 00665. Where you will, are you there?
Yes.
It has already been dealt with, but I'm not going to be very long on it. You have admitted that it is your signature
Yes.
that appears on this document. It's an application for authorization in terms of section 2.4 of POCA.
Yes.
And you also said in paragraph 2, I've perused the documents and recommend the application.
Where do
Sorry,
you get
Counsel,
that?
which,
Beg your pardon?
which volume is that?
LO3, Madam Chair.
LO3.
And the page is LO 0065, 00665.
Yes, thank you.
You have appended your signature on this document.
Yes.
It's common cause.
Just place on record what this document is.
The document, Madam Chair, is an application for authorization in terms of the provisions of POCA, addressed to Advocate Jiba, the then acting NDPP, and it's dated 15 August 2012. And it's signed by Advocate Chauke.
It is addressed to Advocate Jiba by Advocate Nokomashilo and
Yes.
is signed by
Advocate Chauke.
Advocate Chauke.
Yes.
Thank you. Proceed.
You agree that an application in terms of these provisions of POCA is a prosecutorial decision.
Yes.
By signing on this document, you are taking a prosecutorial decision.
No. I was signing on behalf of NOC. That's what we are missing to understand. It's there. And this letter is from Advocate Noko to Jiba, not from me. I don't know where you get that.
Who prepared this document?
Advocate Mayem.
Right. On page 73 of the record, of the transcript, through to 74, Advocate Maema was asked, day 30 transcript, dated 20 February 2026. I've asked that they make copies for me, but I don't have it right here.
It would have been easy if you had warned us about the documents that you're going to use so that the researchers could prepare them timelessly. Counsel.
I apologize for that. I asked the ITs to print it for me, but they delayed. But it's page 73 through to 74.
But you have your junior behind you. Why can't they prepare these documents? The IT team makes documents available online, and advocates, attorneys, and especially juniors must make sure that you have these documents. And at the very least, even if you are not given the documents, our researchers must be told what is it that you plan to use so that we can get those documents timelessly. That would be helpful, Counsel, if you were to go that route.
If you allow me, Madam Chair, before we proceed any further, I just want to ask Advocate Chauke.
Before you ask Advocate Chauke, Advocate Lekgetho should sit next to you. She's NPA, she should assist you. Advocate Mhlamuyane, you were going to ask Advocate Chauke a question before I interrupted you. You may proceed.
Yeah, Advocate Chauke, whilst you are still on this document, the application, the POCA application, did you ask permission from Advocate Nogo before you could sign it as a DPP, as the acting DPP in KZN?
No.
Now, the record on page 73, the transcript is dated 20 February 2026, Madam Chair, where Advocate Mtsweni was asking Advocate Maema was cross-examining Advocate Maema, and he was referred to a centralization application. I'll come to it, Advocate Chauke. The record here, if I may, on page 73, one, two, three, four, fifth line from the bottom, Advocate Mtsweni says, Advocate Maema, that is an application for centralization of charges in terms of section 111 of the Criminal Procedure Act. Do you see that, Advocate Maema? That is correct, Chairperson. Advocate Mtsweni, yes. Now you would agree with me that the centralization is part of the prosecutorial decisions. Advocate Maema says, that is correct. It is ancillary there too. Advocate Mtsweni, yes. Now what you see there, you see a document dated 15 August 2012 addressed to Advocate Jiba from Advocate Chauke. Do you see that? That is correct. Now the point that I want to make is the following. Go to LO3, bundle LO3, LO 00843. Are you there, Advocate Chauke?
Yes.
Madam Chair, are you?
Give me a second.
Thank you.
Thank you.
Thank you, Madam Chair. The document is addressed to Advocate Andrew Chauke, the ANDPP then. It's dated, it's from yourself, Advocate Chauke. It's dated 15 August 2012, where you were making an application for centralization of charges in terms of section 111 of Act 51 of 1977 in the State versus Boysen, Johan Vessel, and 4 others in the Rustenburg case.
Yes.
You remember the Rustenburg case, 1099 of 2009.
Yes.
Now, go to page LO 00846, where your signature appears.
Yes.
You'll agree, therefore, that you were taking a prosecutorial decision.
Yes.
I have no further questions, Madam Chair.
The problem with that is that you did not read the record further, because this was dealt with that was a mistake. You see that it's the Director of Public Prosecutions, South Gauteng, when it was supposed, the application was supposed to be made by the Director of Public Prosecutions, DPP, KZN. So obviously, you have not gone through the record to find the explanation as to the reason and what happened thereafter. But thank you for your concern.
Where does that appear in the record, in the transcript?
If we go through where Advocate Maema was testifying when he was before this panel, where he dealt with and then gave an explanation that was a mistake and that mistake was corrected. I can just maybe get some time and again go through the record so that I can get the actual page.
Yes, of course.
Advocate Chauke, I understand that this is heavy on you because it is your career and profession on the line. But let's try to deal with this, and I know I'm asking a tall ask. Let's try to deal with this with very calm spirits.
No, thank you, Chair. I understand.
I want to assist on the point that you were making. That Advocate Mhlamunyane, you referred to LO 3 00843.
Yes, Madam.
Yes, and that is the document that is written under the hand of Advocate Chauke,
That is correct.
which was later, as Advocate Maema testified, he indicated that it was a mistake which was picked up by the prosecution team. And if you go to the same LO3 at LO 00856, you will find exactly the same document, but this time under the hand of the Director of Public Prosecution, KwaZulu-Natal Division, and signed at page 00859. It has a name M. Nukumashilo, but it's signed PP Maema. And I think during Advocate Maema's testimony, he explained the mistake, and that I think that is what Advocate Chauke was trying to indicate to you. Thank you.
I'll take that. Thank you, Madam Baloimere.
Yeah, that memo, that covering letter that Advocate Mhlamunyane has asked you about, you say that you signed without having obtained consent or permission from Advocate Noko.
I discussed that with Advocate Maema, and he said he arranged with Advocate Noko that I should PP sign that application.
Okay.
So I did not tell Noko to say, no, look, here is Maema, this is what I should do. That's what I'm referring to.
Yes, so you arranged, or you took Advocate Maema's word that he had discussed with Advocate Noko, and you could then go ahead and sign the document.
Indeed, Chair.
Thank you, Chair.
My sister, Advocate Baloy SC, is directing me to the part of the transcript, thankfully to her, page 89, that deals with that application by Advocate Noko, referred to at LO 00856. You see that, Advocate Mhlamunyane?
Yes, I see that, Madam Chair.
Do you have the transcript?
Yes, it's before me.
Yes, do you have page 89?
It's in front of me, yes.
Do you see what transpired during the testimony of Mr. Maema? in relation to this application by Advocate Noko.
I see that.
There was a similar application to that which was made by earlier on, signed by Advocate Chauke.
I see that.
And Advocate Mtsweni there, the bottom of that page. Is addressing us, and he refers to LO 856. The application is now made in the name of Advocate Noko. Then Acting Director of Public Prosecution, KZN, do you see that?
Yes, I see that, Madam Chair.
And Advocate Mayema agrees. And midway that page, page 90, Advocate Mtsweni, yes. Now, the fact that you now decided to make an application in Advocate Noko's name, could that be an acceptance that the application should not and could not have been made in under Advocate Chauke's name? Well, I agree with you. What we realized that even irrespective of us being based in the DPP South Gauteng, the application has to be made from the office of Advocate Noko. You see that?
Yes, Madam Chair.
You can proceed.
I said I have no further questions to put to the witness.
You do not have further questions?
No further questions, Madam Chair. I'm done.
Yes, thank you. Should I understand your response to be an acceptance that although Advocate Chauke says that his signing of the decentralization application signaled that he took a prosecutorial decision, but then he corrects that and says that was a mistake, and that mistake was corrected by Mr. Mayema in his testimony. Meaning, if I'm correct, he did not make a prosecutorial decision. That which he did was an error.
I cannot quarrel with that. It's on record.
You
Yes.
cannot quarrel with that.
Yes, it's on record.
This exercise sought to demonstrate that there is evidence that Advocate Chauke took a prosecutorial decision. Now, with this answer, it means there was no evidence, or there is no evidence in the record showing that Advocate Chauke took any prosecutorial decision. Is my understanding correct?
Yes, it is correct.
Is correct.
Yes.
Yes, thank you.
Madam Chair,
Let me just ascertain from my sisters whether they have any questions.
Advocate Nkabinde, I understand you conceding with the last question, but I wanted to check because you referred us to a number of documents. You referred us to LO3 page, LO00869, paragraph 201, and then LO3 paragraph, page 00871, paragraphs 210 to 211. And I think when you came to the third one, which was LO2 at page 00297, the chair asked you if you were going to link all those paragraphs. Now, and then you further referred us to LO3 at page 00655, which is an application for authorization at paragraph 2, where Advocate Chauke said, I've read and agree with this application. Are you saying, should I understand that you were going to link all these paragraphs together with LO3 at 843, the centralization application, to show that Advocate Chauke took a prosecutorial decision, and therefore, once this last one fell away, they all fell away, or you still maintain that this other 4 instances that you referred us to shows that he took a prosecutorial decision?
Yes, I persist that on these other ones, especially on the 15 August 2012, he took a prosecutorial decision by appending his signature here. And that can be a subject of submissions at the end of the inquiry.
Remind me, the 15th of August 2012, that would be LO3 665, the application for authorization.
Yes.
Okay. Thank you.
15 August, Madam Ramakaha, and 2012, the page is LO00665.
Thank you. You may proceed to re-examine the witness, Advocate Ngcukaitobi.
thank you, Madam Chair. Perhaps, Mr. Chauke, we should start with the last part that Advocate Baloyi SC has dealt with.
Yes.
If I could ask you to look at the transcript at day 30, 20 February 2026, at page 154. Where's my recording? Because I'm at 106. Where does it say it was a mistake?
Yes, Chair, I'm there.
Yes. So if you go to this page, doesn't look like it has lines. No, it doesn't have lines. But it is the portion where Advocate Mtsweni reads the email of the 15th of August 2012. Can you see that towards the bottom of the page?
Yes, I see that, Chair.
It says, if you read the email in the middle there, where I think it is from Advocate Silo Mayema, dated 15 August 2012, where the second paragraph on this email, the last sentence says, I've done the prosecution memo on the KZN letterhead, although our DPP will sign as arranged with acting DPP KZN. Now, can you just comment on that, where Advocate Mayema on email already said he did the prosecution memo and it would be signed by the DPP, our DPP, as arranged with the acting DPP, KZN?
Yes, that's what I was referring to exactly, that there was an arrangement with the Advocate Noko that I will sign on her behalf when that application is being submitted to National Office.
Yes, but that was, according to this, not an arrangement made by yourself. It was an arrangement made by Advocate Mayema.
Indeed.
So is that what you meant when you said, actually, this was clarified in the evidence of Mr. Mayema?
Indeed, Chair.
Yes. And then later on, if you go to page of the same transcript, 156, Mr. Mtweni comes back to this topic. Are you at 156?
I'm at 156.
Yes, towards the middle of the page where it says Advocate Mtweni, starts with yes, Advocate Mayema.
Yes.
Yes, can you see that?
Yes.
Now, Advocate Mtweni says yes, and then poses a question to Advocate Mayema. He says, Advocate Mayema, do you recall earlier when we discussed the centralization application? Remember, there was a first one that was done by Advocate Chauke in his name, and that you said it was prepared by yourself. And then Advocate Mayema said, that is correct. Can you see that?
Yes.
So the cross-examination on this was clear that Advocate Mtweni accepted that the evidence of Mr. Mayema was that he had prepared the centralization application himself.
Yes. And
then, if you look at what it says thereafter, it says, but it was signed by Advocate Chauke. And then Mr. Mayema says yes. And then it says, and then on the 28th of August, you prepared another centralization application. Advocate Mayema says yes. And then he says, and this time signed by you. And then he says, signed PP. And then he says, and that this signature was in terms of the arrangement between yourself and Advocate Noko. Then Mr. Mayema says, where I would sign on her behalf, I would PP yes. And then Advocate Mtweni says, yes, and that arrangement would have been struck between yourself and her directly. And then Mr. Mayema says, yes, that is correct. Mr. Mtweni says, no, not through Advocate Chauke. Mr. Mayema says, no. Can you see this?
Yes.
Yes. Then Mr. Mtweni continues, yes, and I take it the same as the POCA authorization of the 15th of August, where you said there was an arrangement that Advocate Chauke would sign on Advocate Noko's behalf. Yes, that arrangement was done with Advocate Noko, Mr. Mtweni and yourself. Mr. Mayema, yes. Mr. Mtweni directly. Mr. Mayema, that is correct. Mr. Mtweni, without Advocate Chauke's involvement. And then intervention, rather, it says, I would have accepted that the two DPPs would have spoken. Mr. Mtweni, but I mean, when you spoke to Advocate Noko, did you speak to her through Advocate Chauke, Advocate Mayema? No. You spoke to her directly, Advocate Mayema, directly, yes. I mean, can this ever be doubtful?
Not at all.
Yes. So this is what you were protesting when you said, read the rest of the transcript.
Exactly. That's what I was referring to Mr. Mhlamunyana to.
Yes. Okay. The same point, I read to you the cross-examination bit, but it appears that this point was dealt with also in the evidence in chief of Mr. Mayema. On day 28, page 191 of the transcript, 18 February 2026. Page 191, Madam. Yes, so if you start, at the where the page starts, which is the question from myself. I say, it seems this email in particular discloses at the time that you yourself have drafted the letter and made a decision to do it in the name of Advocate Noko. That's why I say to him, the email shows that he made the decision to do it in the name of Advocate Noko. That is Advocate Mayema.
Yes.
Correct. And then Advocate Mayema then responds, he says, that is correct.
Yes.
Yes. And then I say, and that Advocate Chauke would sign as arranged. And Advocate Mayema says, yes.
Yes.
Advocate Ngcukaitobi, I
Yes.
try to keep up, but I'm lost.
Oh, sorry,
left
Madam
me
Palomena.
behind.
It's 191.
191.
Yes. Sorry, I think I'm now also getting lost.
Okay. 191.
So it's day 28 on the 18th of February, 2026.
I've got the wrong files.
Oh, apologies.
We don't have those files with us. They're still in this folder.
I say, I apologize.
You can proceed nonetheless
Oh, I
and just
see.
refer us to the relevant pages of the transcript.
Yes.
We will check.
Thank you, Madam Chair. So we are at page 191, day 28. The date is the 18th of February, 2026. It's the evidence in chief of Mr. Mayema. So we've already referred to the first 4 paragraphs. And after line 10, I think this is line 10, 11, 12, 12th line, where Advocate Mayema says, well, firstly, perhaps let's deal with the question. So I say to him, so does this explain then that this document that a big issue has been made out of, which is the fact that Advocate Chauke has PP'd it with the arrow, that is its source? Then Mr. Mayema says, Chairperson, he had PP'd it because we anticipated we were going to court the next week. Otherwise, what would have happened is that I would then have to carry all these documents, travel to KZN, wait for the DPP, and then engage with the DPP there. When we have a DPP in the South Gauteng office, it would have been more convenient that Advocate Chauke signs, and then it gets transmitted to the National Director.
Yes.
Yes. So that was the evidence in chief, which seems to have been repeated in cross-examination.
Yes.
Yes, and this is what you were referring to when you said, please can you look at the transcript as a whole?
Indeed, Chair.
Yes. Now then, to come back to the original question, you remember the original question was, show us where Mr. Chauke makes prosecutorial decisions.
Yes.
Yes. What do you say about this now that we've gone through the transcript?
There is none. That has not been shown to me until now.
Yes. All right. So your answer when you said, did you make a prosecutorial decision? And then you said yes, and then the cross-examiner says, okay, well, I have no further questions. What do you say about that?
No, that's why I thought it was a misunderstanding or an omission on the part of the evidence leader not to get through to the explanation, because I was answering as a principle to say if that is what has happened, I would have made a prosecutorial decision. That's why I said yes.
Yes, all right. But given the evidence that has now been shown, is it what do you say to that answer?
Yes, that's why I was explaining that that was a mistake, that my letterhead was used and I signed there, because that was discovered the very same day that was a mistake, and it was corrected by Advocate Mayema.
Yes. And I mean, does this come part of this? Because I dealt with this with Mr. Mayema, that they worked with you from a position of trust. They put documents, you don't question them because you trusted the way they were doing things.
Yes, indeed, Chair.
And then when they find a mistake, they also own up to it. It's not as if they're hiding it. It's owned up and then it's corrected.
Indeed, Chair.
Yes, and this whole thing was also explained by Advocate Mosin.
Yes, from the records.
From the record, yes.
And ironically, it's once you explain that this is a mistake, and then like you would accept that it's accepted that people do make mistakes, and I'm also susceptible to that, to making mistakes.
Yes.
In the course.
No, that's fine, no problem. Thank you. Then there was
But on this point, Councillor, suppose the matter has been brought to rest by Advocate Mhlamunyane's acceptance that there is no evidence exercise. And finally, after this clarification, reading the transcript, Advocate Mhlamunyane accepts that other than what he thought constituted a prosecutorial decision, there is none.
Yes, Chair. Thank you.
Yes, thank you, Madam Chair. I'm not following this line any further. There was an issue on the matter of Mr. Mdluli. Just one issue around the question whether it seems that the evidence leaders accept the binding force of the SCA decision, not that they had an option. But it does seem that Advocate Batoyi did not, from the transcript.
Yes.
I just want to refer you to certain portions, which is why we ended up where we are, where the panel is being asked to second guess the SCA. So if we start at day 9 of the transcript, page 37. Apparently the instruction, well, the request was made that for this to be pulled out. Yes. So if we go to the, we are at page 37, at day 9, at should be the 19th line. Can you see that?
Yes, the one that starts so here.
Yes. So this is Advocate Batoyi's, and the only point I'm pursuing with you is to show that the reason we ended up where we are is because Advocate Batoyi refused to accept the binding force of the SCA judgment.
Yes.
And that was all in line with her position that the charge refers to the pre-inquest
Yes.
decisions, which was abundantly clear in the cross-examination. Now she says here, so the NPA appeals the matter and we now turn on to the Supreme Court of Appeal judgment. In this regard, Chairperson, I mentioned that Advocate Chauke has often mentioned, and I think it was mentioned by counsel at the opening, she's talking about me, that the Supreme Court of Appeal decision vindicated him.
Yes.
Yes. And then it seems to go a little bit off script there. That way it stops.
Where did you start reading, Council?
At,
In that is page 37.
I think it is in the 19th line,
Where?
where it says, so the NPA appeals the matter. Well, perhaps, Madam Chair, what would be helpful is to read.
Shouldn't you start maybe a little bit up
Yes, I think so.
to give it proper context?
Yes, I think so, Madam Chair. So if you look at the full sentence of, the full paragraph of Advocate Batoyi, so the question is from Advocate Mhlamunyane, who says, you may proceed to deal with what Advocate Chauke ought to have done after the receipt of this judgment of Murphy J. Then she says, so here we have a really strong judgment that supports the prosecutors who recommended a prosecution. The reinstatement of the matter is ordered. However, in these circumstances, Advocate Chauke does not do that. Instead, he decides to appeal the Murphy decision. The question is why, given everything that had preceded in the inquest and in the Murphy review application and the decision. Now, you explained that the appeal decision was the NTPP's decision, not you.
Yes.
Yes. Then in that condition, she then says, so the NPA appeals the matter, and we now turn to the Supreme Court of Appeal judgment. In this regard, Chairperson, I mentioned that Advocate Chauke has often mentioned, and I think it was mentioned by counsel at the opening, that the Supreme Court of Appeal decision vindicated you. Now, in this inquiry, this current inquiry, you've heard for yourself that the evidence leaders accept that the SCA judgment exonerated you. That's their term, not vindicated, but exonerated you.
Yes.
Yes. Now, there's another portion where she is clearer that she doesn't accept that the SCA decision exonerated you. So that appears at page 105. What day is it? The same day. Also on the 19th line. Yes, remember that earlier she had complained that there was an appeal against the judgment of Judge Murphy.
Yes.
So if you look at after the 10th line, where Advocate Baloyi Mere SC speaks, can you see that?
Yes, that now at the back.
Yes, exactly.
Yes.
Now, Advocate Baloyi Mere SC says, now at the back of your answer and the reasons that you have given, what do you make of the fact that the SCA then overturned that decision of Murphy J? And Advocate Batoyi responds, the SCA may have overturned it, but as I explained earlier, it was critical of Advocate Chauke's conduct in this matter. And in fact, the SCA was also very critical and dealt with the inquest magistrate's findings and seemed to have suggested that Advocate Chauke should have done things differently at that stage of the proceedings. So it does not exonerate him. It certainly deals with his conduct in a critical way. Now, this is the whole point. So for the first time today, we have an admission that the SCA decision has exonerated you. But the problem was their witness who refused to accept the binding force of the SCA judgment.
Yes.
And then Advocate Baloyi Mere continues, which is now day 9, 27 November 2025, the following page, where she says, but that is not part of the order. We as lawyers know that judges will tell us whatever they tell us, give us guidance, but at the end of the day, it is the order that one has to comply with. What matters? We have the order. Then Advocate Batoyi says the order matters. And Advocate Baloyi Mere continues, that is what I'm asking. That is at the back of your answer and your response. Consider the judgment and the order. What do you make of that? Are you still maintaining that the Murphy judgment should not have been appealed? And then she says, yes, I am. And then Advocate Baloyi Mere says, thank you. This is the whole problem, that the NDPP refuses to accept the binding force of the SCA judgment. She is holding on to the Murphy J judgment.
Yes, because it suits her narrative.
No, we'll deal with that later, but I'm just dealing with the facts now. Yes. And then the final one is day 11 at page 95. Day 11 is the date is the 3rd of December 2025. So we looked at the exchange with Advocate Baloyi Mere earlier, I think on day 9, and then this topic is then revisited on day 11 by the chairperson.
Yes.
So if you look at just below line 10, so it's the 11th line, where the chairperson says, just one last aspect, I hear you that as regards the Mdluli matter, you still needed some more information, and you were satisfied as regards the Cato Manu matter, that the matter had to be referred. Then the chair continues, the Mdluli matter, and please correct me if I am missing something. The SCA, the judgment of Judge Brandt, dealt with the Mdluli matter and in my view closed the chapter Now, that view of closing the chapter is actually the view that is shared by Advocate Mayet,
Yes.
meaning that, as I understand the judgment, all that needed to be done following the inquest was for the matter to be re-enrolled or for the withdrawn charges to be reinstituted. Am I correct? Just on the reading of the judgment, which judgment seems to absolve Advocate Chauke. Even that question of absolving is also shared now by Advocate Mayet.
Yes.
And the question of reinstitution is no longer within your hands.
Yes.
It's now with the
And DPP.
Mr. Ngasan.
Yes.
Then she then responds, Advocate Batoy, she says, Chairperson, I want to refer to, I did deal with this matter earlier. She's talking about that exchange with Advocate Baloimer. I want to refer to my notes on this, but my understanding at a very high level of the branch judgment is that it did not absolve Advocate Chauke. I do not mean to be disrespectful. I'm trying to find my notes as I speak. You see. So that's the... Then later on, perhaps let's just read everything. Then the chairperson says, I'm going to request that we park it here. Let us flag that point. All of us will look at that judgment again and then deal with this aspect because it troubles me. Advocate Batoy, it is important, yes, the chairperson, and the reason why it troubles me is because an appellate court has pronounced on a matter and we seem to go against that decision. I just want to understand in respect of which aspects of the judgment did the SCA get it wrong. Then she says, Chairperson, we're not saying the SCA got it wrong. Well, you said earlier that you did not agree with certain parts of the SCA judgment earlier. Then Advocate Batoy, Chairperson, what I mean to say is that we agree with the SCA judgment, but we do not agree that it absolves Advocate Chauke's conduct. Now, see, on this, I just cannot understand how a senior advocate, when a judgment of the SCA looks specifically at your conduct in relation to withdrawing and referring to an inquest and says we do not find anything irrational about the decision, how it can be said that's not an absolution.
It's very unfortunate.
Yes. Then the chairperson continues, that is my reading of the judgment. The SCA did not say I absolve Chauke. The SCA spoke of the conduct of Mr. Chauke or Advocate Chauke not being irrational, if I may use the legal terminology. If his conduct was not irrational, what does it do? It absolves him, in my understanding of the law. Now I want to understand what is it that the SCA, which disfavored, if I may use the terminology, disfavored Advocate Chauke. When we reconvene, before we all forget, let us look at that judgment and maybe you can assist me in that regard concerning the Ramokibe matter. Then she says, I will do so, Chairperson. That is an important aspect. Yes. So it seems this is the whole problem that underlied the referral of the Mdluli case, despite the SCA, simply because Advocate Batoy did not agree with the effect of the SCA judgment.
On the advice of the legal opinion that she obtained after everything is said and done.
Yes, we know that line comes from the opinion of Advocate Hali.
Yes.
Yes, it's just repeated by Advocate Batoy.
Yes.
But today that has changed. Everyone accepts that the SCA, the effect of the SCA's judgment is that you can't be charged for withdrawing the charges and referring them to an inquest.
Indeed, it's just unfortunate that a senior counsel would have just misled Advocate Batoy in that score.
Well, Mr. Chauke, we've done so well so far without
It is not,
attacking.
I beg your pardon, Counsel Advocate Chauke. I do not think it is fair to Advocate Hali to say that it is not fair that the senior counsel would mislead Advocate Batoy.
I apologize.
Advocate Batoy is similarly an officer of the court. She's an advocate, and I think an advocate of a long-term standing. She has been an advocate for a long time. So it is not fair to attribute a blame entirely to an advocate who prepares an opinion.
I accept that, Counsel Chair.
Because she ought to have read the SCA judgment. As you can see in the transcript, we adjourned and said, let's go back and read this judgment again because it troubles me that you take such a view that the SCA got it wrong or did not absolve Advocate Chauke. So she ought to have read the judgment herself, even before the opinion of Advocate Hali, not so.
Indeed, Chair.
Thank you. Proceed.
Thank you. Do you want to withdraw the word misleading?
Indeed, that's why I was apologizing. I'm saying I'm withdrawing that reference.
Yes, no, thank you. Thank you very much. Now, then, there's just one aspect on the matter of Keitumano. You know, do you still have the terms of reference with you?
Yes.
Yes. Now, the chairperson has said that the terms of reference would constitute a charge sheet, to use colloquialism.
Yes.
Now, we went through this in detail with you in evidence in chief, from 3.1.1 up to 3.1.1.5. It's just to ask really if there is anywhere here where there is a reference to you having made prosecutorial decisions.
Not that I'm aware of.
Yes, okay.
It talks about supporting a decision.
Yes, I understand that, but that's about these memorandums we've gone
The
through.
racketeering.
Yes.
The racketeering, yes.
Yes, but those are all the memorandums we've been going through.
Yes.
Yes, but I'm asking specifically whether there is anywhere where you are being taken to task for making a prosecutorial decision.
Not at all.
Yes, and it would have been open for them if they wanted to charge you with making prosecutorial decision to do that.
I think so. It's obvious for me in that regard.
And that's why they've been asking for an amendment to the charges. It's unclear to me how the charges will be amended after the accused has pleaded and testified and been cross-examined.
It was a face-saving exercise so that, like I indicated, to throw a bigger net in criminal prosecutions, we say throwing the book at the accused.
Yes. Oh, yes, thank you. Do you wish to say anything else? This is your last opportunity before you are excused.
Yeah.
You do? Okay, I made a mistake then. No, I don't want to hear anything. Yes. Madam Chair, thank you. I have no further questions.
Yeah.
No, don't answer my question, please.
Thank you, Chair.
Are you done?
Yes.
Yeah. Now, if one is to look at the fact that the charge sheet does not include making prosecutorial decisions, if there is evidence that you made prosecutorial decisions, if there is such evidence on record, would it matter and would it have an impact on this inquiry?
No.
Thank you.
I suppose there is nothing that arose in the re-examination that was new that you would wish to revisit, Advocate Mutlamuyane?
No, Madam Chair, nothing.
In that event, Advocate Chauke, thank you. You are excused,
Thank you, Chair.
at least for now.
I had that I might have to come back.
People have reserved their rights.
Yes.
And should it happen that the President decides on the panel's ruling, otherwise, we may have to re-look at what the president would have done or would have amended, and you may have to come back.
Indeed, Chair, I accept.
It will be quite something extraordinary, though, but let's see what the president does.
I just hope the president will agree with the panel.
We are still, we are still waiting for the presidential decision.
Thank
We
you,
have
Chair.
recommended, and the powers rest with the president to amend or not to amend.
Indeed, Chair. Thank you very much.
Yes, thank you. You are excused, and thank you very much for your patience.
Thank you, Chair.
On housekeeping matters, before we adjourn for tea, Advocate Ngcukaitobi.
Oh, yes, it's now working again. My next witness is General Mabula.
Is General Mabula here, and is he ready to take the witness stand?
Yes, he's ready. He's in the building.
He's in the building.
Yes, he can come up in a few seconds.
Madam Chair, perhaps if I might just come in with your permission. I will be Yes, I will be dealing with the Mabula aspect. I have looked at the statement and discussed it with my leader, Advocate Mhlaminyane, and I have conveyed to Mr. Ngcukaitobi that on analysis of the Mabula statement, there is nothing that us as the evidence leaders would take issue with insofar as his evidence is concerned. And I indicated to Mr. Ngcukaitobi that it might be prudent that we just accept his statement, that his statement goes in without any need for oral evidence. Mr. Ngcukaitobi believes that Mr. Mabula deserves audience, but would ask for the panel's guidance that insofar as the evidence leaders are concerned, we've got no qualm or any issue with General Mabula's evidence, and that his statement, insofar as we would submit to the panel, that it can go in and be accepted as evidence without the need for oral evidence. But then we are in the panel's hands insofar as that is concerned.
Thank you, Counsel. I think that will obviate cross-examination, but it is important that the witness be placed here. We may want to ask him questions. Remember, there is already evidence on record by the previous witnesses referring not once, not twice, to what Mr. Mabula did, or General Mabula did, in the relation to the Katomena matters. So it is important that we allow that he comes, takes the oath, and if a need arises, we may ask him questions as a panel.
Thank you, Madam Chair.
Yes, Counsel, both of you, we suggest that we take a tea break, then start with the witness when we reconvene after tea. We will reconvene at 11:30.
Thank you, Madam Chair.
We adjourn. Good day, everyone. Good day, General Mabula. General, do you prefer to take an oath or affirmation?
I prefer an oath, Chair.
Thank you, sir. Do you swear that the evidence you are about to give will be the truth, nothing else but the truth? If so, raise up your right hand and say, "So help me God."
So help me God.
Thank you, General. You may proceed, Counsel.
Thank you, Madam Chair. General Mabula, in front of you, you should have a copy of your statement marked 7/1. Is that correct?
It's correct, Chair.
All right, so if you go to the end of that statement, which should be page 717,
I have it, Chair.
where your signature appears.
I've got it, Chair.
Is that your signature?
That's my signature, Chair.
Yes, so if you then go to the beginning of the statement, 7.1, paragraph 2 says that the facts contained in the statement are within my personal knowledge. Is that correct?
It's correct, Chair.
And then, are they binding on your conscience?
Correct, Chair.
Yes, thank you very much. Now, so your career is set out at paragraph 6 of your statement within the SAPS, is that correct?
Correct, Chair.
Yes. Can you just briefly deal with that? It seems that you started off as a constable.
Must I read it out, Chair?
No, just a summary that you basically you are a career police officer. No, you can just give us the summary highlights here.
Or just out of my
Yes, you can use paragraph 6 to
1?
yes, to
Okay.
remind yourself.
Thanks, Chair. I joined the police actually in 1983, and then I went to college 1984, where I was a constable until 1987, and I worked as a church office commander in a place called the Laraville, it's in Northwest. And in 1987, 1993, I became a sergeant and a warrant officer, and I became a section head in the Laraville, also in Northwest Province. 1993 to 2000, I became an inspector and captain on the same year, and became acting branch commander at Lichtenburg, which is also Northwest. 2000-2001, I became a superintendent in Klerksdorp Detective Branch. And 2001-2007, I became a provincial commander, serious and violent crime in Northwest. 2007, I became a provincial commander, organized crime. In 2007 to 2010, I became the provincial head, detective services as a director in Northwest. In 2010 to 2016, I became a provincial head for priority crime investigation, which is called TPCI, the Hawks in Northwest. 2016 to 2019, not 2020, I became the deputy provincial commissioner, crime detection in Northwest.
So we should correct 6.9
Yes,
to 2019.
2019, that's my retirement year.
Yes. You also mentioned you started in 1983, but it looks like you started in 1984.
Starting date in the police, when you join the police as a student.
Oh, I see.
So I joined the police 1983. So our service is calculated by the time when you are sworn in as a police student.
So we should be saying 1983,
Yes.
not 1984.
Yes.
So 6.1 also needs to be amended.
Yes.
Okay. All right. Thank you. And then your qualifications, you mentioned that you've got a Bachelor of Technology degree in policing
Correct, Chair.
and a National Diploma in Police Administration.
Correct, Chair.
Where were these obtained?
Technicon SA
Yes.
and the University of South Africa.
So which one was technical essay?
The diploma.
I see, okay.
Yes.
And then the bachelor's degree at UNISA.
Yes, UNISA.
All right. And then, so this CV ends in 2019, which, what have you been doing since then?
Since 2019, I'm employed by a private company.
Okay. Yes.
As a manager.
All right.
Yes, as a manager, not as a general, as a manager.
Mr. General, I see you looking at me. Obviously, you come from my turf, and we are the Northwesterners.
Yes.
So I see you look at me, you smile. I'm just making this disclosure.
I smile because I
you.
feel protected, Che.
I think I must disclose that I know you. I'm sure you remember me.
Yes.
Yes, indeed. You may proceed.
Thank you, Madam Chair. Sorry, so it ends in 2019. You left the police in 2019
This is correct, Che.
in order to work for a private company.
No, it was actually my retirement age. I still feel Southern Police Service is still my home.
I see, so it was a retirement, not
It was
a
a
resignation.
retirement, yes.
And then since then you've worked for the same private company.
No, a private, since then I work for the same private company, yes.
Okay, and you in the security industry or in a different industry?
In the security industry.
All right, I
Yes.
see. Is there a reason why you won't disclose its name?
I feel safe not to disclose.
Okay,
Yes.
that's fine. All right, but there's no reason.
No, there
Yes.
might not be, but I feel very much.
All right, no, that's fine.
Yes.
All right. And then you've also undergone extensive training as per paragraph 7. Can you just deal with that?
I undergot extensive special training, including homicide investigation, forensic disciplines, organized crime, intelligence handling.
Yes. All right. And then I think you were at DPCI between 2010 and 2016, is that correct?
Correct, Che.
And that's the relevant period here in this case.
It's correct, Che.
You were the provincial head of Northwest DPCI.
Correct, Che.
So that's Northwest Hawks.
Yes, Che.
Yes. And then you were at the rank of Major General.
Correct, Che.
Yes. Thank you very much. Which rank you still hold?
Yes, Che.
Yes. And you became a Major General when?
2010.
When you became the head of the Hawks.
Correct, Che.
Yes, all right, thank you. Now, we can then move a little bit far what we've done so far. You know about this case, is that correct? Well, not this case. You know about one of the allegations in this case, which is the Cato Mano issue.
It's correct, Che.
Yes, and how do you know about that?
I know about it when I saw it was actually highly publicized in the media and on electronic media. So day in, day out, it's also been televised.
Yes.
Yes.
All right. But you had prior knowledge because you were personally involved.
Correct, Che.
Can you just take us there? So I've now skipped 3 pages of your statement. I've skipped page 7.3, so the 7.2, 7.3, and 7.4. I'm now in 7.5,
Yes, Che.
where we deal with a factual background.
Yes.
So you can use that, or you can read directly, or whichever approach makes you comfortable.
Okay, I'll read. During my tenure as a provincial head of DPCI Northwest, under Lieutenant General Arnold Ramat, who was the then DPCI national head, I was actually involved in complex investigations and had reputation of handling sensitive matters. It therefore came to no surprise when Lieutenant General Ramat appointed me on 14 December 2011 to lead a team of investigators to conduct a fact-finding inquiry into allegations against members of Katomena Organized Crime Unit in KwaZulu-Natal. At that time, there was a significant public concern, including civil society and human rights organizations, regarding allegations that members of the unit were involved in unlawful killings linked to taxi violence and retaliatory operations. These concerns were amplified by media reporting, including Sunday Times expose published on or about 11 December 2011, which alleged that the unit operated as a hit squad. The article is attached as Annexa NJM1.
Yes, so that will be at page 7A2 of your, 7A1 of your statement.
Yes. Can I carry on?
Yes, you may carry on.
In response to these allegations, and on 14 December 2011, Lieutenant General Dramat formally appointed me to assemble and lead a team to conduct preliminary investigations aimed at assessing the veracity of allegations as reported. We were further mandated to engage with the Independent Police Investigation Directorate, which is IPID, and offer assistance in respect of cases referred to in the expose. My appointment letter is attached marked Annexure NJM2.
Yes, now if you can go to 7A4.
I got it.
And then paragraph 2, that's firstly, what is that document? The document in 7A4.
7A4.
Yes.
It's a mandate, actually, that allowed me to conduct investigations.
So it's a letter written by Major
By General Dramat, yes.
To yourself.
To myself, yes.
Doing what? Mandating you?
Mandating me to conduct a fact-finding mission around KZN or KwaZulu-Natal regarding the allegations that were actually appeared on the Sunday Times during the time.
And who was who was General Dramat?
General Dramat was the national head of Directorate of Public Crime Investigation, which is DPCI, based in Pretoria.
Yes, he was the national head of the Hawks.
Yes.
It looked like what happened really is this: he saw the story in the newspapers himself. If you look at paragraph 1.
Correct.
And then he decided to instruct you to start an investigation.
It's correct, Chair.
Yes. And then paragraph 2, what does it say?
Major General Mabula is hereby appointed to lead the investigation and is directed to establish a team with the relevant competencies to investigate the critical issues that have been identified in the above-mentioned article.
Yes, and then you also mentioned IPID. What does paragraph 3 say?
The task team will communicate with the ICD, which currently is the IPID, and offer assistance in respect of the mentioned 45 cases.
Yes, I mean, this number of cases has generally moved. Sometimes we have 52,
Correct.
Sometimes 45, sometimes 23. Do you know why there was a reference to 45 cases?
I think there was a reference because I think in the newspaper article, that's where it was actually mentioned.
I see.
If my memory serves me well, I have long time not read the article to refresh my memory.
No, I understand.
Yes.
And then paragraph 4, what does it say?
The team must also establish if disciplinary action must be taken against the members and make recommendation in this regard.
So which members are being referred to here?
Referring to Katamena Organized Crime Unit, Serious and Violent Crime Unit.
Yes. Now, there are 3 organizations that are referenced here. There is the Hawks, there is ICD or IPID, and then there is the quote-unquote police. So where would be the mandate of General Dramat to get involved in investigating the conduct of the police and then taking action against them?
Can you rephrase the question again?
So I'm saying in this letter, there are 3 organizations involved.
Yes.
Firstly, there is the Hawks.
Yes.
Then there is the police,
Yes.
and then the ICD. Now, General Dramat is coming from the Hawks.
Yes.
And does he have a mandate to look at the conduct of the police?
He has the mandate to look at the conduct of his own members, which were DPCI, because by that time, Okatomena organized crime, they were actually answerable to General Dramat.
Thank you. Yes,
Yes.
that's what I needed to clarify. Yes. And then you were also the subject of instructions from General Dramat because you
Correct.
were also Hawks Northwest.
Correct, Chair.
Yes. Now, he could have done it differently. He could have said the Hawks in KwaZulu-Natal must look at this thing. Correct?
Correct, Chair.
And but he didn't. He got a Hawks from a different province.
Correct, Chair.
And would you know why?
I would have known what I would say. Maybe if I have to say, I would be drawing an opinion, but I wouldn't have known myself.
Yes, but I mean, is this not simpler that actually the members of serious and violent crime in KwaZulu-Natal were themselves involved? So there would be a clear conflict of interest.
Correct.
So there must be a need for a neutral person from somewhere else.
Correct, Chair.
Yes. So that doesn't seem to be far-fetched. It seems to be straightforward.
Okay.
Yes, thank you. So that explains then how this matter comes to your desk. It's from your boss because he's read the newspapers. Is that correct?
It's correct.
Yes. Now, that was in paragraph 24. And then what did you do thereafter, paragraph 25?
Upon completion of this preliminary investigation, I was required to submit a report to Lieutenant General Dramat containing recommendations regarding any misconduct that might warrant a disciplinary action.
Yes. And then paragraph 26.
At that stage, we did not have access to relevant case dockets, which remained under the control of SAPS KwaZulu-Natal and IPIT. The preliminary investigation accordingly relied primarily on local record center, which is LCRC, material, including crime scene photographs relating to a fatal shooting incident involving members of Ketomena unit.
Yes. And then you start your investigation, following page at 7.7.
Yes.
Correct. And then what happens?
In order to access further material, I contacted Mr. Humbalani Kuba, who led IPIT task team investigating this incident. On 6 January 2012, I met with Mr. Kuba at IPIT offices at 23 Dorothy Nyembe Street, Durban, accompanied by DPCI team members.
Sorry, General. Mr. Humbulani Kuba, was he a member of the SAPS?
Chair, he was actually the member of IPIT.
IPIT.
He was the one who was actually, when our arrival in KwaZulu-Natal, he was the person who was currently leading the team, task team under the umbrella of IPIT.
And he was based in KZN?
No, he was based in Limpopo. He was just as myself deployed.
He was part of the team that was assigned to help in the investigation.
Investigation by IPIT at that time.
Thank you.
Yes. And you met with him on account of the instruction from General Dramat that
Correct, Chair.
You should work in partnership with IPIT.
Correct, Chair.
Yes. All right. And then on 6th of January 2012, you met with him in the offices of IPIT.
Correct, Chair.
And then you referred to DPCI team members that were with you.
Correct, Chair.
Do you remember who they were?
It was Brigadier Mukwena, who is now the general. Brigadier Luwele, he was a colonel. Colonel Mano, Lieutenant Colonel Gola, and who else? I think Warrant Officer Ramakosi. Yeah, among those were the team members.
And how were those selected to be part of this?
I selected in terms of their skills.
You selected them?
Yeah, I had the opportunity to select.
Okay.
The appointment said
yes,
I must assemble a team, so I had a choice too.
And where did you get them from?
Some was from head office, and then some from Northwest and Gauteng.
I see.
Yes.
All right. But you say even your own choice, you didn't select people from KZN?
No, I couldn't.
Exactly. So what is the reason?
I mean, I couldn't because I would have actually, I wanted to be very neutral. I wanted
Yes.
people who are very much neutral in terms of the investigation, objective anyway.
Yes, thank you.
Yes.
Now, then you attend this meeting on the 6th, and then in that meeting you deal with that in paragraph 29.1 to paragraph 29.4. What was discussed in that meeting?
In that meeting, I did inform Mr. Kuba of my mandate from Lieutenant General Dramat, and I clarified that the investigation was, at that stage, not a criminal investigation. I made it clear to him. I indicated that approximately 7 cases have been identified, and I requested access to the relevant dockets.
And then what happened? What did he say?
Then Mr. Kuba indicated that they do not have the 45 dockets mentioned in the expose, but considered that they had complaints which they were investigating against the Ketomena unit.
Yes. You know, one of the things that this panel has learnt over the months of the evidence has been, I would say, the lethargy from the perspective of ICD and IPID, that things just don't move there. Now, you have the encounter here with IPID. I mean, if they are saying to you, we also have complaints, why have they not resolved them?
Well, I don't know whether to comment regarding that.
No, but at the time you were discussing with Mr. Kuba, you know, I can understand you are getting involved late because you've been instructed by
Yes.
General Dramat, but
Yes.
he is telling you we've been sitting with these cases. But the question that arises logically is why? Why have you not finalized them? Because it's 2012. These are cases stretching back from 2008. It's 4 years later.
Yes. No, he actually didn't explain the reason why. So even myself, I didn't ask, why are you actually delaying in these matters? Because I have to forge the relationship, by the way.
Yes, yes.
Therefore, that time, yes.
Yes. Thank you very much. And then you then address a request for forensic expertise. Is that correct?
Correct, Chair.
And in relation to specific cases which are mentioned at 31.1 to 31.7.
Correct, Chair.
And why were these specific cases? I mean, in another correspondence, I think from Mr. Mayema, we learned about 6 dockets, but here you are mentioning 7.
Yes.
Do you know what is the reason? Where did the additional one come from?
Look, Chair, at this stage when I wrote this letter, it was actually not cases.
Okay.
It was LCRC reports. Because what happened from the sources and the complainants and people who shared information with us, they did provide case numbers to us. And then as we approached Mr. Kuba, not necessarily willing to divulge or hand over this, so we work on that LCRC reports. So that's why the cases will be, this will be 7. It's not actually the cases, those were actually LCRC reports.
What's the difference between a docket and an LCRC report?
A docket will be where you have got a complainant, a witness statement. A docket will be actually carried by the investigating officers. LCRC, this is their own docket. It's where now they take photos, their crime scene photos. So that is the difference. So this, what is actually indicated here, will be actually filed in the case docket.
I see.
Yes.
I see. So this forms part of the case docket,
Exactly.
but it's not a case docket.
Yes.
I see. Your letter is at 7A5.
Yes.
And you were asking for forensic expertise.
Correct.
And why?
Because we want to unravel because when you've got the ballistic, he is able to do a more thorough analysis, and then he is also in a position to reconstruct the crime scenes, because whenever we interacted with the local record center in KZN, we understood that not all the crime scenes were actually visited by the ballistic experts. So we knew whenever we summon ballistic experts, we might get more information that can give us direction in terms of investigating those allegations,
Yes.
as mandated by General Dramat by then.
So you wanted more scientific expertise.
Exactly.
All right, thank you. And then you do get your wish in paragraph 33.
Paragraph 33, yes.
And that is when, I think it's Colonel Mangena, but I think he was at the time captain.
He was Captain Mangena, yes.
Yes,
Sure.
he's then assigned. What does that mean? That he now forms part of your team,
Correct, Chair.
your investigative team?
Yes, Chair.
Okay, thank you. And then you commence formally on the 17th of January, is that correct?
Correct, Chair.
Yes. And then as you start, IPIT gives you a list of 52 cases, correct?
Correct, Chair.
And that you will find at 7A7.
Correct, Chair.
Yes. We had this from Captain Mangena as well, the same list.
Yes,
So
Chair.
I'm not going to spend time on that.
Yes.
And then you say that these cases now have broadened because you started with 7 LCRC reports.
Yes.
And then you end up with 52 cases.
Yes.
Yes. Was it clear where the 52 cases, I suppose they were from IPIT, they were not yet dockets, or were they dockets, or were they
Most of them were actually inquest dockets.
inquest dockets?
Yeah.
Yes.
Yes.
Which would mean what? Because we've also heard this term inquest docket, and it's never clear to us how does that differ from a police docket.
Yeah. You know, inquest docket is where actually, for me, my interpretation would be a case docket where actually you don't have a direct suspect into the matter. It's, for me, it's like a fact finding. You are establishing facts. You are not yet sure as to whether what happened. That's my interpretation. A case docket is where now your view is establishing the facts to get more information around the suspect, where because there it will be clear that the crime has been committed. Yes.
Now, how does that work in this case where I think virtually all of the 23 dockets that we have been dealing with in this inquiry, the killers are known. There's no need to do a fact finding about who the killers are because they've written statements where they admitted that they shot and killed
Yes.
people they alleged to be suspects.
Yes.
Why does that go to an inquest?
Well, I wouldn't understand by that time. We were also surprised when we read through the statements and through the analysis of Captain Mangena. Yes. And then when also you go through the witness statement, we were actually a little bit taken aback.
Yes. So your opinion, based on your expertise, would be that this should not have become inquests, because you call an inquest a fact finding because the facts were known.
Yes. No, according to me, yes. That's why we actually pushed, most of these cases were actually registered as case dockets.
Yes, thank you very much. And then paragraph 37, you are now starting your work, correct?
Correct, Chair?
Do you want to comment on that, on the strategies you followed?
Through January, the task team analyzed the LCRC records and began reconstructing crime scenes across multiple incidents. They also traveled to KwaZulu-Natal to continue with the investigation and liaise with IPIT investigating team that was stationed in Durban at the time.
Yes. Thank you. So, but these are multiple trips.
Yes.
People coming in and
In
out.
and out, correct.
Yes.
Correct, Chair.
You were personally involved in virtually all of them.
I was, Chair.
Okay. And then you had security concerns, bearing in mind intelligence reports, correct?
Correct, Chair.
And what were those security concerns that are dealt with in paragraph 38 and 39 and 40 and 41?
On the 20th January, I received intelligence indicate that members of Katomena unit were tracking the movements of task team using SAP's automatic vehicle location, which is actually known as AVL systems. This raised a serious concern. I then conveyed the intelligence to the task team and instructed that the documents and records that the team was analyzing for the investigation must be left at the SAPS Special Task Force offices in KwaZulu-Natal. This facility was provided by then Acting National Commissioner Lieutenant General Nhlanhla Mkhwanazi, who is the current Provincial Commissioner of KwaZulu-Natal.
Saying the facility,
Yes.
Which facility is this?
The facility is where we actually housed our case dockets and so on. It was at the task force, KwaZulu-Natal SAPS task force offices.
Yes.
So they actually provided us with a strong safe where we put in all this, yes.
And that was facilitated by General Nhlanhla Mkhwanazi?
Yes, correct.
Okay. Well, to help your investigation to be protected.
Yes, correct.
Okay. And paragraph 40.
Shortly thereafter, equipment belonging to a forensic team members was stolen from their vehicle, and a criminal case was opened as per Durban Central Case 128001-2012.
Yes, we've got evidence here that from Captain Mangena that the equipment was actually stolen from his car.
Yes, correct.
And his car was one of the ones that were tracked, according to the intelligence, by the Katomano people.
Correct.
All right, carry on.
Alternative, non-tractable vehicles were therefore procured for the task team. These vehicles were provided by crime intelligence.
What does that mean?
It means now that we actually established that we're being tracked by AVL. So the vehicles that were actually allocated to the teams, they were no longer fitted with AVL, which might actually, create opportunity for those who are tracking to follow the team.
Yes. Paragraph 42.
If I may ask, General, why would the Katomena unit members track the movements of your team using this AVL? What was the purpose?
Well, I can only imagine, Chair, to say it might have, maybe, if the case might be, to check the witnesses that what we might be interacting with. And that is why something that I learned in KZN is most of the witnesses or people that you spoke to, whenever you spoke about Katomena, they will just move away the way they were actually afraid of this unit.
Thank you, Council.
Thank you, Madam Chair. Paragraph 42.
This incident reinforced my concern that the investigation was being actively undermined.
What does that mean?
It means that there is possibility of interference into these investigations. The work that we are doing is not really, how can I say, is not really recognized, and then, there's a disruptive element that want the facts not to be divulged to the public.
Yes. And the only people that would have that interest in suppressing the evidence from surfacing would be who?
It would be those who are involved,
Which is who?
which by then allegedly would have been Katomena
Yes.
unit.
And so you're talking about them when you say actively undermined, that
Yes, yes.
you're trying to investigate these people, but at the same time they are trying to sabotage the investigation.
Exactly.
Okay, and then you refer to Colonel Mangena's letter at MJ5, which is at page 7A9. Is that correct?
789. Yes.
Yes. We already called Captain Mangena and he dealt extensively with this letter, so I am not going to ask you to read it. Do you have anything else to say on this letter?
No.
Yes. And then your preliminary investigation was then completed and your report was given to General Dramat on the 31st of January 2012. Is that correct?
Correct.
Now, what did you say to General Dramat?
After giving the report,
No, in the report, what were you telling him you've discovered in the month of January 2012?
no, we analyzed actually 3 dockets. The one was a docket, the one of Durban Central, where Satan Bongani Mkise was actually killed. And the other one was Becky Temba. Just want to check, I think I've made notes of those. Becky Temba case is where actually our report actually was based.
You find your report if it's more comfortable.
And how we case.
I'm saying find it, the report, and then
No, I'm
reference it.
covered. I wanted that information.
You've got it?
No, I've got the information that I
All right,
wanted
then
to
you
say.
can
Yeah.
explain them to the panel.
Yeah, I did compile a report to General Dramat, and in that report, we also highlighted the possible misconduct that would have been leveled
Yes.
against Katomena, those who were involved.
And what were your preliminary findings?
Our preliminary findings was there was indeed misconduct.
Yes.
And and our preliminary report was also that there is a need for a criminal investigation in those matters.
Why? Why is there misconduct and why is there a need for a criminal investigation?
As we are analyzing the case dockets,
Yes.
it was very clear to say it's not actually, it's a very serious crime, and then many people has been shot, and then under mysterious circumstances that are actually raising doubts as to whether it was a self-defense actions.
Yes.
Yes.
So you discovered that the version given in the statements in the dockets by the police is possibly false.
Yes.
Yes. And that these are murders and not self-defense, are possibly murders, not self-defense.
Not self-defense, correct.
And then your view was that when you say there is misconduct, what does that mean?
Misconduct in a sense of, because there is a, what do you call, a code of conduct by the police, how they should behave. So once you contravene that, it might emanate, it result into a misconduct. There are regulations that actually one would have actually be charged with.
Yes, but what is the misconduct and committed by who?
The misconduct was, for example, if I go to the files, I have just to read what the time our reports actually said to General Dramat. If I have it quickly here, where is it? Can I just find time? I think I brought it. Yeah, sorry. Yeah.
You can read from it if it's better for
I'm
you
just
to do
going to
that
check.
way.
Yeah. The first, let me just check, because we summarize case by case. Sorry. Okay. The first docket that we actually summarized, it was Durban Central 185 of 2009, Umgeni, the one against the deceased Mr. Bongani Mkhize. After analyzing and do some fact-finding mission, and then we did recommend to General Dramat by then our findings and recommendations, and then we said into that we said, but it's a long thing, so I'm not sure whether our findings was we referred to Mr. Mkhize as the chairperson, and then we also summarized the actions by all the members. And then our recommendation that time, we say it is recommended that the investigation be instituted in terms of Regulation 12 or SAPS Discipline Regulation 2006 against the following members. That was in terms of Mr. Mkhize. Major General Boysen, Regulation 20, in that on about 21 October until 3 February, at about 1300 hours and at near Durban, KwaZulu-Natal, he allegedly failed to comply with legal obligation by failing to ensure compliance to the court order obtained by the deceased Bongani Mkhize, as a result of which he was killed. That was our recommendation that time, our first.
Just stop there, because you see this issue around Mr. Bongani Mkhize, we've dealt with it extensively in this inquiry, but we've never dealt with the fact that there was a specific recommendation that Major General Boysen should face disciplinary action around this because he failed to ensure that there was compliance with the court order. What did you mean that he failed to ensure compliance with the court order?
What we meant by that time, remember, he was actually the custodian of, or he was actually the one involved in the Asari affidavit. So my expectations was, or our expectation was, he should actually have communicated the final order to his members and put measures in place to say, in case when Mr. Bongani Mkhize was sought, that's where the issues that were supposed to have happened. But then we say on the same to say, but he is the person who goes to the crime scene, but he can't recall that actually there's a contravention already in the same matter. So he never instituted anything against or any misconduct against his own members.
Yes. In his book, he describes the court order as superfluous and redundant.
Well, I haven't seen the book. I heard about the book.
Yes. Now, you can take what I'm saying because we've read it and we read it as part of the record here.
Yes.
But what is your comment on that? That you are saying, well, in law, he was expected to ensure compliance with it.
Yes.
But he describes it as superfluous and redundant.
It can be redundant and superfluous.
Yes.
Because the High Court actually have sanctioned that it needs to be observed.
Yes. Okay. Then there's an alternative finding.
Okay. Alternative, it was Regulation 20 Z that on about 3 February, about 1300 hours near Durban, KwaZulu-Natal, in that he allegedly committed a common law offense, to wit murder, in which the deceased Bongani was the victim, via Durban case 185/2009.
Can you just explain why you came to the view that Mr. Boysen must be held accountable for the death of Mr. Mkhize?
I came to the view, or we came to the view at that time, because had he actually applied or complied with what the court has actually said they need to comply with, Mr. Mkhize's life would have been saved.
Yes.
Yes.
All right, carry on. What other recommendations did you make?
Warrant Officer Stolz, Warrant Officer Padiache, Warrant Officer Dlamuga, Constable Lee, and Constable Mfene. The same Regulation 20Z, in that on about 3 February, about 1300 hours and about near Durban, KwaZulu-Natal, in that they allegedly committed common law offense to wit murder in which the deceased Bongani Mkhize was the victim via case 185 of 2009.
Yes. And why did you choose this group of police officers to put them in this bracket of being responsible for the killing of Mr. Mkhize?
Because they were the first people who were in the vicinity of the crime scene, and in terms of the analysis that were done and exhibit the crime scene as it was analyzed, they were actually implicated into this.
Yes. Well, I mean, they admitted that they shot him.
Yes, they admitted, but the question was it necessary to shoot him? Is it true? The way they actually, in terms of their explanation, in what happened, the events, how they unfolded, it didn't actually make sense.
No, I understand what you're saying, but I'm saying that there is no need for a complicated explanation about why they must be responsible for his killing, because they admitted that they shot him.
Yes.
So they must go to court and explain whether it was self-defense or it murder.
Exactly.
Yes.
Yes.
And then what else did you recommend?
Well, then we went on to Howick's case.
Now, Howick is the killing of Mr. Magojela and Nkabinde
Yes.
on the 16th of September 2008.
Yes. I just want to check our
And Mr. Thokozani Tembe, his bodyguard.
Yes.
Yes. What did you say about that?
Just want to check. Okay, here we actually, our recommendations was we said with regard to Magojela and his bodyguard, Thokozani Tembe, were arrested on 29/8/2008 on the N2 freeway near Mbangeni with the joint effort of Warrant Officer Ndlovu and of Dog Unit and Warrant Officer Klope. Handed over to Katomena to organized crime unit members, released them on the basis that they were not linked to the murder of Lieutenant Colonel Kronko. Katomena organized crime unit members told Warrant Officer Ndlovu of the DEG unit to in future call them before arresting any suspect linked to their cases. It is recommended that an investigation in terms of Regulation 12 of SAPS Discipline Regulation 2006 be instituted against the following members. It was Warrant Officer Paul Mostert, Captain Lochem, Captain Eva, Warrant Officer Makanya, Warrant Officer Nell for possible contravention of Regulation 20 as well. The one I've already read.
Why?
Sorry?
They have contravened the regulation in what manner?
In that, on about 16 September, about at near Howick, Peter Marisburg, KwaZulu-Natal, in that they allegedly committed a common law offense to wit murder in which the deceased Magojela Nkabinde and Thokozani Tembe were the victims, via Howick case 106/9/2008.
Yes, and in this case, they also admitted that they had killed him.
Yes.
And they also admitted that Mr. Thokozani Tembe was running away when they killed him.
Yes.
And so you say they must be charged with murder.
Exactly.
Yes. Okay, what else?
Camperdown, 96/1/2009, January 2009. Our findings and recommendations. On the 21st January 2009, an information was allegedly received that a group of African males was intending to commit armed robbery in Pietermaritzburg. Katomena organized crime unit members met at the garage on N3 where a briefing was done regarding the make, registration letters and numbers of the vehicle as a white Kombi ND 306-772, which was to be used in the intended robbery, and the fact that there would be robbers were armed. A decision was allegedly taken to stop the vehicle which was to be used and intended robbery on the road as a location and intended robbery was unknown. The aforesaid vehicle was spotted, stopped exchange of gunfire was ensued, resulting in the death of 5 of alleged 8 suspects. The vehicle in which the alleged 8 suspects were traveling was hired taxi. 3 suspects and the driver were arrested and charged on Camperdown case 96 of 1/2009 for attempted murder and possession of unlicensed firearm and ammunition. Can I go to the recommendation? It is recommended that an investigation in terms of Regulation 12 of SAPS Discipline Regulation 2006 be instituted against the following members: Lieutenant Colonel Olivier, Warrant Officer Paul Moster, Captain Lockham, Captain Eva, Warrant Officer Makaya, Warrant Officer Ganes, Warrant Officer Lashman, Warrant Officer Wolfard, Reservist Constable Potgieter, Constable Gumede for possible contravention of Regulation 20Z.
And why?
In that, or about 21 January, near Camperdown, Durban, KwaZulu-Natal, in that they allegedly commit a common law offense, to wit murder, in which the deceased Nhlanhla Linda Majosi, Molozi Nkabinde Ntuli, Peter Apollo Siwele, Sipokuhle Msomi, and Jabulani Cele were the victims via Camperdown case 96 of 2009.
Yes, so
Yes.
it's the same thing. Is the policemen admit that they've shot and killed these people? You say, well, go and face a murder charge then.
Yes. So there was the 3 cases that we actually presented to General Dramat as a preliminary report, in our preliminary report.
Yes, no, that's fine. What we should do then, your report must be copied for the panel once you are finished with your testimony.
Okay.
Yes, the document you are reading from.
Okay.
Now, you've now told General Dramat that, look, we've looked at this thing. There's actually 52 cases.
Yes.
We looked closely at 3,
Yes.
and there's a picture that's emerging there. What does he say to you?
Because it was still ongoing, our investigation was still ongoing. By that time, he did accept, but I think he was still thinking of the next plan, because the next plan was he was supposed to appoint investigative capacity that will deal with this, because we were only doing the fact finding.
Yes.
Yes.
But what did he tell you as the team that is appointed? Well, you as a leader of the team.
I think that time it was still early stage. Remember, this was the first cases, and then obviously would have given progress report. So I'm not sure as to whether he would have left us to complete all what the assignment he gave to us, and then whenever we complete with our fact finding, then he will appoint a person who will carry on with the investigations. So I'm not sure by that time, but that was the report we gave to him.
Yes, your report is clear that these people are responsible for the murder of these alleged suspects, and they must at least be taken to a disciplinary hearing,
Yes.
if not charged criminally in a court of law.
Yes.
Did that happen?
I believe it happened.
Yes.
Yes. It happened.
These disciplinary hearings?
Yes, but after some time, I think during the time of General Pierre.
No, General Pierre was not yet the National Commissioner at the time you made your report. Was she the National Commissioner?
No, I think General Mkonas was the acting, because this was a long investigations. So that's why I'm saying I don't know what the view of General Dramat was by then, whether he expected us to complete the assignment and thereafter to assign another team.
Yes. Now, what I'm saying, at the time you made the report, I mean, no one actually took disciplinary steps. These people must be suspended from work. Their firearms must be taken, and then they must be taken through a disciplinary hearing.
No, at that period, no.
Yes, that's what I was asking.
Yes.
All right, thank you. And do you know why? You know, this is extremely serious that these people are operating like a hit squad, but you are saying they must be disciplined. No one disciplines them.
Like I say, maybe as we go on, I'll justify why maybe during that short period, because even our mandate actually changed.
Yes, but
Yeah.
you don't know why they didn't do the simple thing of taking them to disciplinary hearings.
No. Though, like I said, ultimately they were taken for disciplinary hearing.
Yes, I understand.
Yes.
But the problem with labor law is that you've got to take disciplinary action promptly.
Yes,
Otherwise, evidence disappears.
exactly.
Yes. Now, then you brief the minister. Which minister are you talking about in paragraph 45?
I'm talking about the late Minister Mthetwa, may his soul rest in peace.
Okay, so, and what was the reason for briefing the minister?
Well, actually, this meeting was initiated by General Dramat. I think, General Dramat, then Lieutenant General Mkonazi, and then head of IPIT, I think it was Mr. Beekman. So we were actually called to a meeting. So I can't explain what was actually the reason why we were called in that meeting to what was actually necessary for us to be there. But we were called to come and present.
Yes, well, it seems that according to paragraph 46, the purpose of this briefing was to provide the Minister of Police with a comprehensive and factual account of the investigation and a progress account.
Yes.
But could I suggest that it probably was because this was a high-profile matter which was already in the news?
Yes, maybe, yes, possibly so.
And
Yes.
so he wants to know what are my officials doing about it.
Yes.
Yes. Paragraph 47, you are now in that meeting. What happened?
At that briefing, DPCI presented its investigation findings, the one that I already shared with
Yes.
the panel. Colonel Mangena presented the forensic and ballistic analysis on behalf of DPCI task team. IPIT reported on its criminal investigations.
Yes, if I can just stop you there. You know, there was something made in this case, I'm not sure if it will be persisted with, that Colonel Mangena's reports were signed in September 2012. That was after the signature of the indictment. How is that possible? But you actually suggest that his reports, some of them were ready as early as March 2012.
Yes.
Okay.
General, you have just mentioned that IPID had to finalize their criminal investigation. Just to avoid the confusion, at paragraph 29.2 of your statement, you make it clear that the investigation was at that stage not a criminal investigation. At what stage did it assume its criminal nature, or was it a mistake?
No, it's not a mistake. In that paragraph, I think I was trying to explain to Mr. Kuba to say our mandate is not necessarily criminal investigations, because we are aware that criminal investigation was actually falling under their own terms of reference.
Yes.
So I just wanted to explain to him to say our mission here is a fact-finding mission. Actually, we are not here to interfere with their own criminal investigations.
Yes, but what you also conducted was, in any event, also a criminal investigation. You've just mentioned now that you then had to finalize the report on the criminal investigation. Did I get it wrong?
No, our report was more on internal misconduct. Though we are referring to case dockets, but we were actually focusing more on internal investigation, misconduct of our members, because obviously criminal investigation was actually done by IPID themselves. Yes. It's only at a later stage when we combined forces, then we had an input now into criminal investigations. Yes.
Thank you, Madam Chair. I think the public will be rightly confused, because when you recommend that someone must be charged for violating a regulation
Yes.
because they committed murder,
Yes.
the public understands the murder to be a crime.
Yes.
They don't understand the distinction being drawn between violating a regulation and being charged for committing murder.
Yes.
They are wondering, why are the police not taking this person to court if they committed murder?
Yes.
You see what I'm saying?
Yes.
Can you educate us on that?
No. The only difference here is if it's a mandate of police, I'm investigating a case of, let me say what, a rape case, if it's my mandate. The police are the custodian of that docket. They are investigating. That investigating officer is in the police detectives. But it doesn't mean as when this investigation, criminal investigation carries on, there's a duplication in terms of misconduct. Now, the misconduct can be finalized very quick. It's where a member can be discharged from the service and all those things. But the criminal investigation is apart. It's not necessary to say you combine them.
All right. So they overlap, but they're done by different
Yes.
units within the service.
Yes.
But the evidence is the same.
The evidence, it might be the same, yes. So in this case, IPET are the custodian of the mandate in terms of the police conduct criminally. But we as police, we also have to make sure that the internal investigation is conducted so that when a member is actually found guilty, because the balance of probability is what we actually focus on in this side, and then a member can be, even before the criminal case is finalized, he can be discharged from the service, he can be suspended, all those sanctions can be.
I see.
Yes. I'm not sure whether
No, I think
I tried to explain.
you've clarified it. Thank you very much.
May I just follow up? General, when people, when you make a recommendation that maybe in terms of Regulation 20 for a person
Yes.
to be investigated
Yes.
through disciplinary proceedings,
Yes.
do they look at the nature of the complaint in order to decide whether a matter should be attended speedily or not, or do they just follow a normal a list as the first come, first serve, or first in, first out?
Any misconduct needs to be attended speedily.
Now, looking at this misconduct, it's a misconduct where the police would continue to be in possession of the firearms.
Yes.
It's the misconduct where police have admittedly killed people.
Yes.
And in your view, when you look at this type of transgression, would you, or rather, what is your attitude or view relating to such policemen continuing to be placed in possession of firearms lawfully for purpose of execution of lawful obligations or duties?
Okay, my view always, I'll respect the outcome of the investigations, because obviously someone will have to be appointed in terms, as we recommended, someone needs to be appointed, do a thorough investigation, collect all the material evidence, and then there must be a panel that will be formed, and then the member will need to be tried disciplinary.
And you say ordinarily, matters as such as the one of the three cases that you've spoken about in the recommendations are such that they are in the normal course of things or business of the police service carried out speedily or attended speedily.
Yes.
And what would you say about these three? Were they, according to you and your observation, were they attended speedily?
No, they were not.
Do you have an idea as to why they were not handled speedily?
I don't know. Maybe the idea might be, like I said, you see, it's always problematic where an inquest docket, mostly inquest docket, sometimes it's a way that can actually confuse some people to say if it's an inquest docket, maybe the charges were actually opened during the time. I'm not sure what would have been the reason for that. But having said that, it doesn't really say a person who is a supervisor, if he go in depth and go through whatever happened here, he would have decided otherwise.
Yeah, you say the Regulation 20 inquiry
Yes.
or investigation can run parallelly
Yes.
with the criminal
Yes,
investigation.
yes.
So that being so, in all probability, or rather you can educate us about that, as to on whose desk is the Regulation 20 Enquiry
The employer.
placed?
The employer.
It is the employer.
Yes.
And the murder docket
The matter docket, obviously, it goes to criminal court.
to criminal court.
Yes.
Okay.
Yes.
No, then that's fine. Thank you.
Yes, thank you, Madam Ramachach.
If I may, Counsel, General, you may be aware of the evidence of Ms. Williams, who was a member of formerly ICD, which later became IPID. Am I correct of that, the successor, that succession? Initially, Independent Complaint Directorate,
ICD, yes.
and later you became IPID.
Yes.
Ms. Williams, in relation to the question my sister is posing to you regarding the delays, she gave an impression that she became frustrated sometimes in the execution of her investigative duties when she found that members of the SAPS, who were also conducting parallel investigation, were making it difficult for them to even access the crime scenes. And as the then head of the Hawks who got involved, were you aware of those challenges?
They did mention because at some stage we did interview Ms. Williams. He was one of the people that actually we interviewed. He did highlight the challenges that they had. But having said that, I don't think the province where I'm coming from, where I used to work, there was no such interference. Actually, the first thing, what is happening currently, whenever there's a crime scene where it is clear that it's a IPID investigations, the members at the CSC, immediately there's already a number where they have to inform IPID. And when IPID arrives at the crime scene, it is their crime scene, it's handed immediately to them. That is the arrangement. I think the Act also provides that. So in terms of investigation, they become actually our superiors. We become actually lesser than involved because they are investigating us. That is my understanding. Yes.
So in the eyes of the public, especially those people who became victims because of the conduct of the police, in this instance, the conduct of the Katomena members,
Yes.
and they see the IPID investigators not really getting to grasp the challenges or deal with the investigation properly, what then that makes of your office, IPD? You're supposed to police the police.
Chair, I'm actually not from IPID. I'm not sure whether Chair is referring. Are you?
You are okay. Weren't you ahead of the Hawks?
Yes. Chair.
And was that not IPID?
No, Chair. Hawks is more linked to the police. IPID is an independent police directorate.
Yes. I
And,
don't know why I get it wrong.
Yes.
And who would have been responsible, the head of the IPID then?
They would be.
Who would have been the head of the IPID then?
By then, it was Mr. Biekman, Frank Biekman. He used to be the chairperson at the Portfolio Committee when he left the IPID.
Yes.
Yeah.
Right. But what role then did you play as the head of the Hawks in relation to these issues that were raised by Ms. Williams?
No, this were raised during the time when we were at work, focusing on the specific investigations. So in other words, I couldn't have corrected. It's things that were brought to my attention, and then we pushed together with the IPID members, we did the criminal investigations.
Yes, thank you.
Thank you, Madam Chair. General Mabula, I think the Chair's question is still a relevant one, which is, we have a funny scenario in this case where the disciplinary hearing is not proceeding, the one you've recommended.
Yes.
But at the same time, an external body like IPID, which is independent, is also not able to carry out its investigation because it is being blocked by the police.
Yes.
You see. And that I think that's where the question arises, what then? Because an independent body can't do its job because Cato Minor is resisting. Yourselves, you mentioned in your statement, you are also being monitored and tracked and you're being blocked. So, and that's why the mother of Kwazindlovu, the 16-year-old boy, will ask themselves the question, but who's going to look after me as a member of the public if people like General Mabula cannot make progress because they're being monitored?
Yes.
People like Ms. Shamila Williams cannot make progress because they're being blocked and monitored.
Yes.
I think that's really what we should honestly account to South Africa about.
Yes. So,
Well, I think you should give an explanation to the extent that you can in terms of what you encountered when you went to Katumano, because it is truly astonishing that no one has been able to crack the problem of Katumano, even now, and we have Ms. Batoy who just withdrew everything.
yeah. Look, for me, my observations, if I have to come, my observation in when I was, what I experienced, it was, for me, it's like the members, Katumena, they were actually law unto themselves. And they were actually respected for their own deeds because no one would actually stand against them. That is, in short, what I can say.
Yes, but I think that is fine, but you cannot be a law unto yourself unless the system enables you to be a law unto yourself. So it's clear that there was a breakdown in the accountability systems. You can't have a unit that just does it as it pleases unless it's enabled. So where was the enablement coming from?
Well, I'll look always to the head. Because if the head is not right, things is always not well.
And what do you mean by that?
So, like I said, when in terms of the late Bongani Mkhize, to say the head of the Hawks General Boys, and by then,
yes,
he should have actually set an example. That was a very perfect example where he should have actually started this, because it was very clear. Because he had an interdict with him, and then he knew what was his own responsibility. He should have communicated clearly to everyone to say, this is how we're going to deal with this matter from now. It would have actually prevented a lot of loss of life.
Yes, thank you.
Interfering, I understand the concern of Advocate Ngcukaitobi to be exactly what you are now saying, that he's the law unto himself, he ought to have done 1, 2, 3.
Yes.
But he's saying, but why is he allowed to do as he pleases? There was a court order granted,
Yes.
and to say, well, he is doing this cannot help us much. And it does not answer the question, why are they allowed? And it will start from the top, from who is allowing.
Yes.
And why is the system like this? Put otherwise, and if I'm mischaracterizing your question, you will correct me, Advocate Ngcukaitobi. But it's about, but why are we here? We have systems.
Yes.
And in this case, it's 3 heads that are put together. It's the IPC, the IDC, the SAPS, and
Yes.
and even, but then still, this coach is not moving. You may correct so that when he answers the correct question.
No, Madam Ramachakhi, that's exactly the question. Especially because you've been assigned to investigate this,
Yes.
and you are from outside,
Yes.
and the system is rotten in KwaZulu-Natal.
Yes. No, like I said, I'll still say it is command and control. People are doing as it pleases them. There's no one who sees wrong. That is the observation that I could draw. I can't say more than that. But it is also the responsibility of the top management structures who sees these things to make sure that it didn't recur.
Would that have included the DPCI head General Dramat.
It would have,
Seemingly, he was in the top structure somewhere
Yeah.
in.
it
the
would have
police.
included him, Chair, according to me, if he is proving that he is aware. But for me, not talking on his behalf, I think we need to, by the time when he saw this on the newspapers, immediately assembled a team to say, go and find out what was happening. So to me, once he said that, I draw a conclusion to say he might have seen this thing for the first time. I'm not, that is my view.
He would, after seeing the publication, the Sunday Times publication in December 2011,
Yes.
correct?
Yes, yes, Chair.
That necessitated your appointment.
Yes, Chair.
Remember the publication, the death squad, shoot to kill,
Yes,
the publication in the Sunday Times.
yes.
That should then later have necessitated him to make a follow-up and check what was happening with these matters that was the public great concern.
Yes. It's true.
Did he make a follow-up?
No, the only time that I know he make a follow-up is just when he assigned us to do the investigations. But also I want to bring to the attention of the commissioners to say, chairperson, to say, there was something that actually bothered me in terms of what happens when this newspaper article was to the public domain. On the 14th, there was General Boysen assigned his member to do internal investigations.
On the 14th of what?
14th of January, is it January? Yeah.
Following the publication in December.
Following the publication. But what surprised, that member did this investigation in one day finalized. And then what I also realized, because it was based on this picture where people were having the same, were having NJM1, where people were having these firearms and having some drinks. Now, there is a statement there of a person from one of the chain stores who actually pulled, because
What is the name of the chain store?
Spa.
Spa.
Yeah.
Okay.
He pulled this crime scene to the office because, according to us, this actually mostly happened in what you call Melmoth. Melmoth, yes. But in terms of his statement, what he says, no, these people actually assisted him to crack one case because they had a spate of armed robberies. And then as a reward, he actually offered them a party and he gave them this. Then he says, no, but this thing actually happened in their offices. Now, based on that...
Sorry, just before, I think you are going to lose us. Let's just get to know what you are talking about. Now, there are three pictures at 7A1.
Yes.
7A2.
Yes.
7A3.
Yes.
Now, which one was taken at Spa?
No, look, what is happening, Chair, this person who did the investigation, this member, he actually combined the pictures as it is. So in other words, if you want to derail that investigation, you want to derail it, and then I say, but this thing actually happened. Somebody says it happens at this crime scene, it happens at the offices. It didn't happen at where all the public is looking at. Now, based on that, now you kill this case. So in other words, you actually shifting the crime scene to another place as an internal investigation. That is one thing that actually bothered me. I came across there to say, but this kind of a serious case like this, misconduct is done today, it's finalized today. So I'm coming back to what I'm saying. It was like some, people there, it's law unto themselves.
Yes, I understand, but I'm still trying to understand the involvement of SPA. So you said that one of the pictures where these policemen are celebrating, drinking, and they've got firearms.
Yes.
That was taken inside the premises of SPA.
No, no, no.
I see.
I'm not saying that.
All
I'm
right.
saying a person submitted a statement
Yes.
from SPA
Yes.
to justify why these people had these drinks. He's the one who bought these drinks. And then they were celebrating among themselves as a result of the reward. He actually rewarded them for their work well done in terms of preventing that robberies that were taking place around SPAs.
I see.
Yes.
So they could have been celebrating elsewhere, but the money came from SPA.
According to that statement.
Yes, I understand.
Yes, according to the statement.
Yeah, no, it's all alleged, but I
Yes.
want to know what is the allegation that they helped a SPA shop where?
No, there was, at some stage, there was this change stores.
Yes, I
Spas
understand.
and so on. Then
Yes.
my suspicion is there were a number of change stores that were actually robbed,
Yes.
where people are complaining, and now they approach the police to say, hey, we've got this problem, it's a threat to us. Now the police, through their own assistance, they manage now to neutralize that threat. Now, as a thank you, then people are offered this to say, get some liquor and so on, enjoy yourselves.
I understand that.
Yes.
But I want to know where did this take place, where the police do their job, which is to prevent crime, or maybe they don't because they kill people. And then an owner of a shop takes it upon themselves to buy them alcohol.
Well, I'm just referring to the statement itself.
No, I understand. I want to know what the statement says because it is an extremely serious thing that in this country we have shop owners that are bribing the police. So what was the statement actually saying?
Well, I don't have the statement with
I understand.
me.
We can
Yes.
find the statement
Yes.
easily, but I want to know from your recollection what...
My recollection is
Yes.
what I've said.
Yes.
These members, they assisted us in terms of a threat, which
Yes.
was actually spate of robberies, and as a result of that, a thank you for them. That's why they were celebrating that way.
Yes.
If I have to summarize the statement itself.
I understand.
Yes.
But this money was taken from, it came from SPA as a thank you to the members of the police.
Obviously, if the statement says,
Yes.
one can conclude.
Yes.
Yes.
Now, there are 3 files that you read. There was the Mkhize file. We know that's got nothing to do with SPA. And then we've got the Howick file. That's got nothing to do with SPA.
Yes.
And there's a third one, which is Camperdown.
Yes.
Is that the one?
No, I'm not sure whether it's the one.
Yes. Okay. Well, I mean, what were the facts in Camperdown? I thought Camperdown was where
Camperdown is the
spate of robberies.
No, I think, it was spate of. I'm not sure whether this statement is linked with Camperdown. I'm not sure.
Yes. Well, just go back to your report because I think when you read Camperdown, you
Yes.
mentioned robberies.
Yes, I did. But what I'm trying to say, I'm not sure whether it's a robbery in terms of SPA itself or other businesses. I'm not. I can read the report.
Yes, I understand. Because I need to know where we're going to find the allegation that a shop owner is buying alcohol for the police.
I think I'll just check in my files and then.
Yes,
Yeah.
because that must be looked at very closely.
Yes.
Because it's one of the problems this country is experiencing. Yes. Now, so you are saying that there was an allegation that someone from SPA had bought alcohol for the police.
In terms of that report of the disciplinary, as a result of these media articles,
Yes.
it was being said. But on the same, I think they said 2 people, they already left the police. Only 1 person was actually given a warning, a verbal warning. And the rest, nothing happened.
Yes. Now, we can deal with the internal issues of the police because we've already covered that
Yes.
there is widespread misconduct. It's not being dealt with.
Yes.
There is IPID. It's ineffective. The angle we hadn't looked at is the fact that there are private businessmen that are buying alcohol for the police as a thank you when the police have allegedly done their job. So that's what I was asking. That's the substance of the allegation that you read.
Yes, that's what the allegation says.
Thank you very much. Now, we were still at paragraph 48. I think we've covered that. The minister then issues an instruction, correct? Which
Yes.
is paragraph 49.
Yes.
And what is the instruction?
Minister directed that IPIT and DPCI teams be integrated into a single joint task team. This would be an IPIT investigation, but I would lead the team of investigators.
Yes. And now they're saying, look, the fragmentation doesn't work. You've got to work as a unit.
Yes.
All right. And then were you the team leader?
Yes.
All right. And then you continue going back to KZN as per paragraph 50.
Yes.
Then you deal thereafter with the involvement of the NPA.
Okay. Following the minister's directive that the investigation proceeds as a joint criminal investigation, I formed the view that given the scale, complexity, and sensitivity of the matter, the investigation required active prosecutorial guidance from an early stage. I accordingly contacted the Acting Director of Public Prosecutions for KwaZulu-Natal, Advocate Simpiwe Molojwa, with a view to arrange a meeting to discuss the matter. During that call, Advocate Molojwa indicated that he was unwilling to meet at the offices of the National Prosecuting Authority, which is NPA. He requested that we meet later that day in a parking area outside SAPS provincial headquarters in Durban. I regarded this request as unusual. However, I nevertheless complied with it.
So just explain this to me, because it's also another unique aspect of this case. You know, we know that IPIT is being frustrated because of the evidence we've had. We know that you yourselves are being tracked by K2Man. What we didn't know until now is that even the NPA officials were doing things in a very odd way. So can you explain this idea that don't come to my office, I'll see you in a parking lot, from Advocate Molojwa?
Well, look, I didn't understand why, because for me, I was a little bit taken aback because it's a high office, yes, where official matters need to be discussed, yes, into that. But when you take them out of that high office and to the street, so for me, that time I didn't understand why by that time, before I met him.
I see. But
yes,
you said, okay, if you want to meet,
yes,
in a parking lot, so be it.
Yes, because I was desperate, because I realized this. There was no actually when when we interacted with IPIT, I could see that there was a lack in terms of prosecution's involvement into the matter.
Thank you.
Yes.
I'm a bit slow. No, there are times when I'm very slow in my thinking.
All of us.
Advocate Molojwa is the head of the NPA in KZN at the time, as an acting.
Yes, Chair.
And he does not want you to meet him at his head office.
Exactly, Chair.
He wants to be somewhere in a parking. Okay. Then I think I understood well.
Yes, thank you. And then you meet him at the venue that he has suggested, which is paragraph 54.
Yes.
And then what happens there?
Late in the afternoon, but after hours, Advocate Molojwa and I, accompanied by team members, met at the venue. During that meeting, I briefed Advocate Molojwa on the nature of the investigations, including the allegations arising from the Sunday Times expose and subsequent developments following the ministerial briefing. Advocate Molojwa informed me that in his assessment, prosecutors within KwaZulu-Natal would be reluctant to become involved in a matter of this nature. He explicitly stated that members of Ketomena Organized Crime Unit were dangerous and that this created a real concern for prosecutors who were working within the province. In light of these concerns, he advised that prosecutorial support should be sourced from outside KwaZulu-Natal and indicated that the matter ought to be escalated to the Acting National Director of Public Prosecution, Advocate Nomgcobo Jiba. He undertook to make contact with Advocate Jiba on my behalf and revert to me. Later that same day, Advocate Mlonjwa confirmed that he had spoken to Advocate Jiba and that she was available to meet. Arrangements were thereafter made for a meeting at the NPA National Office in Pretoria.
Yes, if you could just stop there. I mean, again, we are now learning for the first time that actually one of the reasons for the involvement of external prosecutors was because the head of the NPA in KwaZulu-Natal was himself too scared of the Ketumano unit. Is that
Yes,
correct?
it's correct, Chief.
Yes. And that he said no one in KwaZulu-Natal will touch a case involving this unit.
Correct, Chief.
Yes. Now, I want to link then this issue to why there were no prosecutions emanating from this case, because these dockets on the evidence we've had were in fact sent to the NPA and it declined to prosecute all of them. The NPA in KwaZulu-Natal.
So that might confirm what the advocate actually relates to me, if that is the case.
Yes. It might confirm that at least one of the explanations is that these people were just too scared of this unit.
Yes.
Yes. And then he then decides that you'd rather go to head office.
Correct,
Yes.
Chair.
Now, the reason why this is crucial is because the impression so far we've seen from the documents prepared by Advocate Mlonjwa is that he is approached by Advocate Jiba with no context that the head office involvement emanates from his office. So he's created the impression that he just got this call, which he didn't know where it was coming from. And then he was told that we will be bringing advocates from outside.
Not according to my knowledge. What I'm presenting to the commission is what I know it happened.
Yes.
The
No,
other
I know,
version, I don't know.
And I'm just putting to you that,
Yes.
that the impression he has created was that this was just done by Advocate Jiba
Okay.
on her own account.
Okay. So my side, it's not true.
Yes.
Yeah.
Well, and why did you speak to him as yourself? As you said, look, let me talk to the prosecutors.
I spoke to him because for me it makes sense. I'm new in that province, and then I realized we need the support of his own staff members, which are prosecutors. The same way I did with Advocate Jiba, where he referred me to. He's the boss of that province, and then I must explain to him, these are the frustration of the team. Can you please assist? So that is the reason why I have to speak to him.
Yes, I mean, one of the requirements of a prosecutor is the prosecution without fear.
Yes.
Do you want to comment on that?
No, it is true, yes. That is one of, he should act without fear or favor, the same as us, or without prejudice.
Yes, I mean, the thing that is startling for me in this narrative contained in paragraph 53 to 58 of your statement is the fear.
Yes.
Then you do, in fact, go to Advocate Jiba from
Yes.
paragraph 59.
Yes.
And then what happens thereafter?
Must I go to paragraph 59?
Yes.
Okay. Earlier in the week of the 5th March 2012, I met with Advocate Jiba in Pretoria, VGM building, accompanied by late Colonel Mano. At that meeting, we presented the same briefing previously given to the minister. I indicated that the investigation into certain dockets was nearing completion and prosecutorial support was required to provide the necessary guidance in the investigation. I conveyed the concerns regarding the reluctance of KwaZulu-Natal-based prosecutors as communicated by Advocate Mlojo.
Yes. And then paragraph 61.
Advocate Jiba then inquired whether I had a preference, which actually I want to mention to the commissioner. I was actually I was surprised because that was actually not my expectation to say, if you require help, someone would say, are you able to choose? I could know General Dramat gave me opportunity to choose, but for the second time, I am afforded the same opportunity anyway. So,
In other words, you could not choose prosecutors.
yeah, but I could because I'm offered. So,
But you're not even in that. Well, how should I put it? Because you have also studied law,
yeah.
but you are not a practitioner,
Yes.
a legal practitioner, in the
Yes.
sense that you will be in a position to even exercise that invitation
Yes, but-
to make a choice.
Yeah, but maybe let's not. Maybe choose is a big word. Maybe prefer. Let's go. Let's go to prefer.
Doesn't it make it worse?
Okay, then I withdraw. Okay, all right.
So,
Okay.
paragraph 61.
Okay, and then Advocate Jiba then inquired whether I had preference or no a prosecutor who could lead the prosecution team. I indicated the only prosecutor I knew with the required expertise to assist with the investigation was Advocate Sello Maema in Northwest Province, because obviously I'm from Northwest. He's the only one that I knew by that time. Advocate Jiba indicated that he has no objections and also proposed Advocate Matenjo, because he specifically asked me when I came with, but my observation, I don't think he knew Advocate Mayama as I know him, because when I said Advocate Mayama, before he responded, I think he was trying to figure out who is this advocate. But on the same breath, he said to me, but do you know Advocate Matenjo? I said, no, I don't know, because honestly speaking, I didn't know Advocate Matenjo, but he said he's referring to a case of Jub Jub. He said, man, that is the advocate that was dealing with this matter of Jub Jub. I said, okay, I heard about him. Then I have confidence also in Advocate Matenjo, because he dealt with Jub Jub matter. Yes. So can I carry on?
Yes.
Okay. Shortly thereafter, Advocate Jiba indicated that she had engaged Advocate J.J. Smith, the Director of Public Prosecutions in Northwest, to facilitate the secondment of Advocate Sello Maema to lead the prosecution team. But also what I want to add here, the way I was so surprised, when I left office of Advocate Jiba, I immediately phoned Advocate Maema to apologize, to say, Advocate, I went there, I made a mistake, I mentioned your name, you might be called. He didn't even know about it.
Yes.
So, the way I was actually surprised.
Yeah.
Yes. So, subsequently thereto, I attended an introductory meeting in Durban with Advocate Matenjwa, Ntlakaza, Fuchani, Jabulani Mlochwa, and Moleko. I was leading the DPCI team, and Mr. Kuba led the IPET team at the meeting. At that meeting, the prosecutors were briefed on the progress of the investigations and provided with approximately 52 case dockets for prosecutorial consideration.
Yes, Advocate Jabulani Mlochwa is not Advocate Simpio Mlochwa that you met.
No.
Who said that, expressed the fear that the Katomena unit was considered dangerous by the prosecutors in KZN.
No, it's not the same.
It's not the same.
No, it's not the same.
Where was he from, this Advocate Jabulani Mlochwa?
He was from the office of Advocate Chauke under correction. Yeah, from Gauteng DPP.
From Southern Gauteng.
Yes.
South. Gauteng South. Gauteng South. Yes, thank you. Thank you.
During this engagement, Advocate Machenjwa indicated that Advocate Maema would assume the role of lead prosecutor, but that he was temporarily unavailable as he was finalizing existing commitments in Northwest Province prior to joining the team. Following the briefing, Advocate Matendra indicated that he intends to meet with Advocate Simphiwe Mloja at KwaZulu-Natal office of the National Prosecuting Authority to formally advise of the team's arrival and to also provide an update on the engagement with the investigation team. The meeting thereafter concluded. Ultimately, Advocate Mayema and Matendra assumed leadership of the prosecution team.
Yes, and then at this point in time, the prosecutors have been engaged. You've been engaged to work in an integrated fashion with the IPID. And you've also now been beefed up with the forensic expertise you were asking for.
Yes.
Was there any shift then in the gear of the investigation? Did you get the sense that we're making progress, we're getting somewhere?
There was. That's why ultimately there were people charged.
Yes. Just to come back to Advocate Simphiwe Mloja's expression of fear. I mean, so that's one angle of explanation about why the NPA KZN was not involved. But we also have other evidence that it's, in fact, the NPA KZN that aided and abetted Katomano just by not prosecuting them, constantly shifting the goalposts and referring to inquests and then issuing nolle prosequi certificates. Names have been mentioned, like Advocate Steinberg, who was working in the office of Advocate Shamila Batohi, specifically mentioned by Ms. Shamila Williams as one of the people that just refused to prosecute the Katomano cases and put obstacles every time the IPID brought dockets for prosecution. So it would seem that there is that explanation. Maybe the two are not necessarily inconsistent, but it seems that inside the NPA, people worked hand in glove with the Katomano. And then those who were not inside then used this excuse of being afraid. I mean, were you aware of the fact that the people like Advocate, I think it was Anton Steinberg, just wouldn't touch Katomano cases and in fact actively dissuaded people from prosecuting them?
No, I don't know much of prosecutors in KwaZulu-Natal.
Yes, and we also have evidence from Mr. Mhlongo speaking about the current DPP, Advocate Harrison, who actually worked with one of the police officers in a case to prosecute Mr. Mhlongo, and was accused of making a false insertion on an affidavit. She is the one who ultimately withdrew all of the cases against the Katomano police officers.
Okay.
Yes.
I take note, but I can't comment on that.
Yes. Now, I put both of those
Yes.
explanations to you because you've mentioned this issue of
Yes.
the fear of
Yes.
Advocate
Yes.
Mloja. Yes, thank you. Now, at this point in time, Advocate Chauke is not yet involved. Or at least you don't know about his involvement.
No, I don't know about his involvement that time.
Yes, the two
Yes.
prosecutors that are in charge of the
It's
prosecution.
Advocate Mayema and Advocate Matendra.
Advocate Matendra.
Yes.
You mentioned Advocate Chauke at paragraph 70,
Paragraph 70.
yes, of your statement.
Yes. Can I read?
Yes, please.
Okay. We did not interact with Advocate Chauke. We only met him during the first appearance of the accused persons in the regional court in Durban.
Yes, now. So he was just there attending,
Yes.
yes, but not playing any role that you could see.
No, because I remember that the person who was even opposing bail, it was Advocate Matendra.
Yes.
Yes.
And then from paragraph 71, you deal with the subsequent developments after the appearance in the regional court. So that appearance, we know it was in June 2012. I think, yes, I think sometime around the 19th or
Yes.
20th of June 2012. Yes. But that was before a decision was made to authorize racketeering charges, which only came on the 17th of August,
Yes.
2012.
Yes.
Yes, carry on. You say after that they were charged?
As I was 71.
Yes.
Following the conclusion of the investigation phase, Major General Boysen and members of the Cattlemen Organized Crime Unit were arrested and formally charged. The matter was subsequently transferred to High Court, Durban, where it was at the time, pending the postponed to 4 October 2019. I came to learn that the charges were withdrawn by Advocate Chamila Batwe in her capacity as the National Director of Public
That
Prosecutions.
2019 must be wrong, because that postponement would have been 2019. Is that correct? Let me ask you.
I'm not, yeah. I thought it's correct. I can. Maybe I just have to go to the notes.
All right. I suppose they're talking about the postponement after Advocate Sean Abrahams, because at the time, this was still under Advocate Jiba.
2019, no.
No, I'm saying this postponement could only be the postponement during the time of Advocate Sean Abrahams,
The
because
postponement.
Advocate Batoy assumed office in February 2019.
2019, yeah. Maybe I might be confusing.
Yes.
Yeah, I might be confusing
Right,
both
but,
of them.
I mean, nothing turns on it, but you may proceed.
Okay. In January 2015, I was removed from my position as a provincial head of Directorate for Priority Crime Investigation in Northwest by Major General Mabula and transferred to SAP as Detective Service. Notwithstanding this, I remained involved in the investigation. I expressly requested to be excused from further involvement on the basis that the matter fell within the mandate of DPCI, and that request was refused. Following the appointment of Lieutenant General Libya as a national head of DPCI 2018, I again requested to be released from any involvement in the Cattlemen investigations. That request was likewise refused. A copy of correspondence reflecting this request and refusal is attached as Annexure NJM6. I ultimately retired from SAPS as a Deputy Provincial Commissioner Crime Detection on the 31st December 2019. That's where I excused myself.
So if you look at 7A13, 7A13,
7/8/13.
this is a letter from, I think, at the time, the head of the Hawks, General Libya,
Yes,
saying that you're not going to be excused until the matter is finalized.
yes,
Yes. And that's in 2018.
yes,
Yes.
correct.
And then you got yourself excused by retirement.
Yes.
Yes. All right.
General, given the fact that you were involved right from the time when, after the publication in the newspapers in 2011,
Yes, Chair.
was the refusal, not in hindsight, was the refusal not a fair one or a reasonable one?
It might be fair, it might not have been fair.
Reasonable?
It,
As someone
yeah.
who has been involved
Yeah, it
right
might,
from the start?
yeah, it would have been reasonable, but the only problem is now I had a workload that would have actually prevented me to focus into this matter. But also, Chair, for me, the investigation was actually basically finalized. There was not much of me actually to input into the matter.
In 2019?
When I requested to be excused.
Was that in 2019 or a little bit earlier?
It was a little bit earlier.
Earlier.
2015.
Yes.
Yeah, 2015, yes. Almost. it was issues of people going to court, finalizing, it was, yeah, so. But it was refused. I didn't win. My request was never actually adhered to.
My next question, if you can't answer it, say so.
Yes.
When you heard of the withdrawal of the charges by Advocate Batoyi, were you not taken aback,
I
given
was.
what you had learned during your involvement in these matters?
I was taken aback in terms of the knowledge that I had, what actually transpired during the time of our investigation, the difficulties that we had, the work we were working almost 24 hours around the clock on these matters with the prosecutors, the hard work, and then all of a sudden it's just thrown out. But
Why were you surprised?
I was surprised because though I'm not a prosecutor and it's not my work to decide on, but the little experience that I had, to me, it seems there was a prima facie case. That's why I was surprised. But I regard myself as a layperson. I'm not in the space of prosecutors.
Thank you, General. I
Yes.
understand. Thank you.
Yes.
Thank you.
Before you proceed, General Mabula, when you requested to be removed in 2015,
Yeah.
or let me preface, there was this general fear that you observed starting from the witnesses that you wanted to consult with. As soon as you mentioned Ketomena, they walk away. The fear that was displayed by Advocate Mlojwa. Wouldn't you say that got to you and you decided you want out in 2015?
No.
You were not scared
No.
of the Ketomena at all?
When I joined the police, I was told. When I joined the police in Delareyville, I was told to say, this, when you join the police, is either you survive or you don't survive, you serve the people. You are the shield of the people. So that was my belief.
In 1983?
Yes. So that is why I never had a protector. I never had anything.
Thank you.
Thank you, Madam Chair. You say that you feel necessary to mention that you had no personal interest in the matter. Why? In paragraph 74.
Because of some of rumors that came, for example, I appeared before the Zondo Commission,
Yes.
partly because of the same, to say I had been captured by someone that I don't know, and there were a lot of allegations that were leveled against me. So, but good enough is Judge Zondo didn't actually take into consideration. He declared that, according to him, this is not a state capture. The police are doing their work.
Well, I mean, there have been consequences virtually to everyone involved in this case.
Yes.
Mr. Chauke is facing a disciplinary hearing on the same issue.
Yes.
Mr. Mayema was purged out of the system.
Yes.
Mr. Matendra is facing a disciplinary hearing. Advocate
Yes.
Shamila Williams was
Yes.
pushed out of the system.
Yes.
Everyone who has had anything to do with the prosecution
Yes.
of Keitoman has been visited with adverse consequences.
Yes.
What about you?
I appeared before High Court. I was charged with 11 counts.
Yes.
Kidnapping, murder, torture. No, it's not murder. Torture, assault, 11 charges
Yes.
before the High Court.
Yes.
And I went through. The judge even asked, because as a lay person, the money is in SAP 30 on one case of the airport. it is clear the money is there. Now you are charged with extortion. Now the judge asked, where's the money? The judgment was 1 page, but I went through that. The same attempt with, it started also at the Zondo Commission, the same allegations were made to say, this person and so on. So, but I keep on going.
Yes.
Yes.
But I mean, this pattern of retaliation, how is it possible that you are arrested? Is it simply because it's entrenched within the system that these people you are dealing with were very powerful and they could retaliate?
It's powerful people. It's powerful people because I can say many times my name was flung all over the news. You link with the same as Advocate Chauke sitting here, the same as Advocate Maema, because of, and they always refer to the same case. Those are the people who did this. It's always the case. But because we have got this thin skin and we are actually loyal servants to the state, it didn't actually deter us up until we have to appear before the judge on 11 count of charges now. You know, it's not very easy to appear before the judge. It's very difficult. I've experienced that.
Well, there's a judge here.
It's not easy.
And are you finding it easy to appear before me now that I announced that...
No, but now I know I cannot be sentenced to somewhere. Yes.
But if I may ask, the 11 counts, were they related to your investigation of the Ketomena unit?
Variety of, like I said, I was very much unfortunate, or maybe fortunate. All the complex cases that actually has a bearing to high-profile people will always be directed to me. I don't know what would have been the reason, but it's a concoction of not only one case. And end of the day, all the people that are investigated, somewhere along the line, they became very close to one another. So I would say this is not the High Court matter is not also not separated from this one.
Probably because of your experience as a senior police officer, not so?
I might not judge myself a chairperson. I don't know whether I'm doing the correct things, but what I know, I'll do everything to my best of ability.
Yes. And this case brought against you, you say is a concoction. What did the judge think about it?
No, judge was very. The judgment is he was saying this thing. He actually agreed to say he's surprised why people have been charged 11 counts, kidnapping, and kidnapping. He even said the people that are kidnapped, they appear before the regional court magistrate. Bail were opposed, and then some of them they got bail. But whether the kidnapping comes in, it was. But nevertheless,
But I mean, the judge acquitted you
he did.
in a judgment that was not more than a page.
Not more than 1 page.
Yes,
Yes, 1 page.
yes, exactly. Which
I was certainly not a judge involved in that.
Oh, no.
which shows how baseless the whole thing was against you.
Yes.
Yes, and which is why you're saying ultimately the source of the problem was Ketomena.
Yes.
Yes,
It's one of those.
because you touched the untouchables.
Exactly.
Yes. Thank you very much. Do you have anything else? I think we've finished virtually what you are saying. Paragraph 75, 76, 77, 78, 79. You say you've made the statement voluntarily and in good faith.
Correct, Chair.
You confirm that.
I confirm, Chair.
Yes. Oh, yes. Your statement is not dated. When did you sign it?
I signed it yesterday as well.
Which is the 30th of March, 2026.
30th, yes, sorry.
Thank you, Madam Chair.
Advocate Mchweni, you had earlier expressed an indication that you will not cross-examine, but you might have revisited your earlier view. Would you like to ask the General some questions?
Yes, Madam Chair, with your permission, just one question. And I would like to put it under the clarification category, if I might, with your permission, Madam Chair.
Yes.
Good afternoon, General.
Afternoon, Advocate.
Yes. General, just one question, and this is just a bit of a concern because your evidence is given under oath, and so is so are all the documents given here under oath. Now, at paragraph 70 of your statement, you say, "We did not interact with Advocate Chauke. We only met him during the first appearance of the accused persons in the regional court in Durban." Do you see that?
Yes.
And the first appearance was the 21st of June 2012.
Yes.
Now, what is of a bit of concern to me, I'm not sure whether would you have that document. There is a statement by Advocate Chauke
Yes.
wherein he gave his evidence before this commission, which I just want to compare with what you say. I'm not sure whether you have Advocate Chauke's statement, Madam Chair. Just the paragraph that I'm concerned about is 117 of Advocate Chauke's statement. Does the panel have it, Madam Chair?
Yes, 117.
Yes. What Advocate Chauke says that on or about 11 June 2012, I met with Mr. Buchman of IPID and Advocates Matenjwa to review the status of the investigation. And on or about 12 June, I convened a meeting with General Mabula and the prosecution team to discuss updates. Do you see that?
Yes, I see.
Which suggests that you held a meeting with Advocate Chauke on the 12th of June. Because we know that according to him, he convened a meeting with you and the prosecution team. Do you see that?
I see.
Which one of the two, and you say on your version, the only time you met Advocate Chauke was at the first appearance, which is almost 7 days later.
Correct.
Now, you'd agree with me that the two statements are inconsistent with one another, where one says you met on the 12th and the other one says you met on the 21st. Although yours, I'm using the 21st because that was the date of the first appearance.
Yes.
So you'd agree that the two statements are inconsistent with one another.
Yeah, the two statements, but I met him first time at the first appearance.
You never met him before that?
No, I never met him before.
Okay, thank you, Madam Chair.
Did you attend that meeting?
No.
No further questions, Madam Chair.
Nothing else, Madam Chair. Thank you.
General, we take this opportunity to beg your pardon. Thank you. General, we thank you for having made time to come and assist us to present this evidence. We know that you might have traveled to come here yesterday
Yes, Chair.
or day before yesterday or whenever you came. We are deeply thankful to you for having made time. And I'm sure I'm expressing this gratitude also on behalf of my sisters and the panel and the two teams, the evidence leaders, NPA, and the team of lawyers on behalf of Advocate Chauke. You will be excused, and we wish you to travel safely.
I also just want to thank the chair and the panel at large for the opportunity to come and share the little information that one have, and hopefully it will add value to the decision that the panel, the difficult decision that the panel will take. Thank you. I want to thank you very much for that.
Yes, thank you. Thank you, General. Housekeeping matters. Advocate Ngcukaitobi.
Madam Chair, I will provisionally close Mr. Chauke's case. And if necessary, in due course, I will reapply to reopen it. But for now, the case is closed.
Advocate, thank you, Counsel. Advocate Mohlamunyane and Advocate Mchweni and your team, we are going to adjourn as planned. Of course, unless you have a witness to start now and finish at 5 o'clock. Please tell us what your plan is for the 8th when we reconvene.
Not today, Madam Chair. The plan for the 8th is that General Boysen should be here, as arrangements have been made that he should be here. But what frustrates me is that up to now, I don't have a statement. And I requested and made so many requests.
Please speak louder, I can't hear you.
I'm saying up to now, I don't have a statement. And as I indicated last week, it's beyond me. I tried my best that the statement should at least have been in by the weekend. It wasn't, and it isn't up to now. But I've made arrangements with Advocate Setati on his security detail, because he requested that. And his counsel wrote a letter and assured us that he will be starting on Tuesday, the 8th of April 2026.
Is that not the Wednesday?
It's a Wednesday, sorry. Yes, Wednesday. My apologies.
Yes, I understand the challenges that you are confronted with. Nonetheless, you had presented to us a list of witnesses that the evidence leaders intend to call. By now, we should be having witnesses lined up. If you would take out Major General Boysen from the list, you should be having other members, or rather other witnesses who had been identified and should have been consulted with by now. Are statements ready in relation to those other witnesses?
Advocate Riley's statement was supposed to have been ready by this weekend, as I discussed with Advocate Mchweni. But I'm not sure yet whether it is ready or not.
Perhaps we should go back to your list, if you can remind us, the list of witnesses that you had given us last year.
Madam Chair, can we excuse Mr. Mabula?
I beg your pardon.
Sitting there
I had
respectfully.
I had actually excused the general to walk out. Yes, General, I had excused you and said we are now dealing with housekeeping matters. But once again, thank you very much. You are excused. Sorry, I didn't realize that you are still sitting there. But now that you've been sitting, you see how we work. You are excused, General, and safe journey. Thank you, sir. Thank you, Council. I didn't realize that General is still here. Where's the list? As the General is preparing to walk out, we can proceed. Do you remember the list of witnesses that you presented to us last year?
Yes, I remember the list, Madam Chair.
Do you have it in front of you?
I don't have it in front of me.
Perhaps we should do tick boxes now that we know that some of these witnesses that you had identified have, for instance, Advocate Mponenogo have now testified. In the list that you presented to us, the first witness identified was Advocate Simpiwe Cyril Mlochwa, and you had anticipated that you'll need 5 days for this witness. What is the position with regard to Advocate Mlochwa's testimony? Has he been consulted with? Has statement been prepared?
Yes, Madam Chair, his statement is being prepared. Advocate Hali SC has taken over finalization of the statement, and very soon it will be signed. The next one on the list.
Before you proceed to the next one, why is it that we have not even had a sight of that statement today, when this list was given to us last year? We are now going to adjourn for the Easter weekend, and we don't have a single statement from the evidence leaders. What is the cause of the delay in relation to the statement of Advocate Mlochwa? If he's still going to be called, by the way. Do you know?
Yeah, initially I had prepared a statement for him, and I spoke to him and I discussed the issue with him concerning his prior evidence in the Mokoro inquiry as well as in the Zondo Commission. And he said to me he would like to go through that evidence before the statement could be finalized. And that is where it was, and he did not revert to me, but he spoke to my colleague thereafter.
Which of your colleagues? Who is that colleague?
I had requested that, I think my memory serves me well, it's Advocate Chauke, to speak to him and see to it that the statement is in. And thereafter I spoke to Advocate Hali, and I gave him the draft that I had, and he said he will finalize the statement with him.
And when was that?
I think it was last week.
Last week?
Yes, Madam Chair. Now, another one who I spoke to.
Let me give you the names according to your list.
Yes, I've got it in front of me.
The second one is Advocate Riley. You anticipated that you'll need 4 days to deal with Advocate Riley's evidence.
Yeah, Advocate Riley is going to be called, and he will be led by Advocate Mtsweni, who informs me that his statement is 90% done. And number 5 on the list.
No. Before you proceed, Councillor, we want to know why are these statements taking so long? This is what we are speaking about last year, December. Now we are almost in April. We have not even been given any of the statements of the people that you have listed here. And we need to understand what the challenge is. We have had breaks, long breaks. We also had a recess break of about a week, not a long time ago. Nonetheless, we have not been given a single statement by the evidence leaders. That is a matter of concern to us.
It should be,
Because,
Madam Chair.
you only have April. You remember you had the entire of December to proceed with the evidence of the witnesses that you had listed. That did not happen. You subsequently sought postponement. We have had some breaks. The time within which the evidence leaders should have expedited finality of those statements. But today, we are back to square one. We don't have statements. We are going to adjourn without any statement to read in preparation of the hearing. How are we supposed to deal with that? Advocate Mchweni, why is the statement of Advocate Riley delayed?
Madam Chair, I would consider there's a bit of a delay, but I was comforted and relied on the fact and the undertakings that were provided that Major General Boysen was coming on the 8th. And in fact, I don't know whether Advocate Mhlawumbe has seen, there's an email from Advocate Boysen's advocate confirming that Major General Boysen will be here on the 8th. So with the intention was that it should be circulated as early as it should be settled over the weekend, and then it'll be circulated during the course of next week whilst Advocate Boysen was giving evidence. That was the idea. I just need to discuss a few matters with Advocate Riley, and then the anticipation was that I would start circulating it during the course of early next week, whilst Advocate Boysen was giving evidence. Because we've always been assured and given guarantees by Major General Boysen's legal team that he will be here next week. And in fact, there's an email that we received, I think, during today or yesterday, where there's still that undertaking that Major General Boysen will be here on the 8th.
But why is the finality of other witness dependent on General Boysen's testifying or his statement being ready? Because we should be having all statements in a pack, well prepared for us, timelessly.
Well, Madam Chair, I appreciate that, but I was comforted by the directive that was issued that statement should be in at least 2 days before, and I'm confident, and has always been confident that that statement will be in within the required time period, insofar as I'm concerned.
Perhaps you can read the third witness, because this computer is... Who is the third witness?
The third on the list was Advocate Mipone Noko. She's already testified. The fourth on the list is General John Boysen. The fifth on the list.
Before you go to the fifth, Major General Boysen's mention was made that his statement is very long.
True, Madam Chair.
And remember, we are aware that you started consulting with Major General Boysen's last year, November, before we even started with Advocate Batoyi.
That's true, Madam Chair.
And today, we don't have a statement of Major General Boysen. Are you going to prepare a summary of that statement for us, of the issues that you seek to focus on, at least in relation to the terms of reference? Because the terms of reference should guide all of us. You can have a statement of 10,000 pages, but we have to focus on what is relevant for the purpose of this inquiry. When are we going to know when the statement will be finally filed, Advocate Mhlamunyane? Because we are going to leave Gauteng, some of us. We may not even have access to connection wherever we will be. That poses a challenge.
I agree and I appreciate that, Madam Chair. If we don't receive a statement from Johan Boysen, I cannot prepare a statement. His evidence will be left out. I cannot prepare a statement because I was told right on my face that the attorneys, his lawyers will prepare a statement, and after I had begun with a draft, which draft I also indicated to the Chauke team that I'm busy with the draft, but after that, they took over. And I spoke to General Boysen and I asked him, he said, yes, I've given instructions to my lawyers. So I backed off and sat back and waited for them to give me a statement. So I'm not going to prepare a statement if I don't receive a statement from them.
Yes, I understand that. He is your witness, and if he's not ready to come, you'll let us know.
I'll let you know, Madam Chair.
Thank you.
Thank you.
And Advocate Chris McAdam.
I spoke to Advocate Chris McAdam in a telephone conversation a month or so or two ago. And then we made an arrangement that we'll talk on another arranged day. When I spoke to him on that day, he said to me, he was told by Dr. Broughton that before he speaks to me, he must first speak to Advocate Karen van Rensburg. I said, Chris, do that, I'll wait for you. He did not revert to me until a few weeks ago. I telephoned him and we arranged that it was a Friday, and we arranged that we'll talk on the Monday. And on the Monday, he wrote me a note that said he will no longer be able to, he will not assist me because he was not involved in the Katomana dockets. He has not read them, and he will not be able to assist. He's busy in the TRC reviewing many dockets there. So I said, Chris, it's fine. So Chris McAdam is off.
And Ms. Karen van Rensburg is the advocate in the NPA.
That's correct, Madam Chair.
General N. Mkhwanazi.
I have a draft of General Mkhwanazi's statement, and for the past few weeks, he has been busy. The last time when I contacted his staff officer, he said to me, he will not be able, he's not available. He's going to Parliament, to the ad hoc committee. And up to now, he has not reverted to me.
Officer Makubo.
I consulted with Officer Makubo and finalized his statement. And Officer Makubo referred me to an advocate with whom he was working. I can mention in passing that Officer Makubo was identified to us by Miss Mary DeHaas. I took it from there. Now, when I consulted with the advocate who Makubo referred me to, it came out that we are not going to proceed with this matter. I also prepared the statement of the advocate, who was in the office of Advocate Chauke. And we were warned that to stay away from this, because if you proceed with the second docket in the Senzo Meyiwa case, your name is death. So leave this thing. Don't proceed.
I don't understand.
Officer Makubo was assigned to investigate the Senzo Meyiwa murder. According to him, he and another officer, Officer Joyce, was a captain then, were summoned by the then Minister of Police to Cape Town, and were assigned. There were four. They were assigned to deal with the Senzo Meyiwa case because apparently the minister was not happy that the investigations were bearing any fruit.
But how do we get to the Senzo Meyiwa matter? We are talking about this witness testifying here.
But
are you ready with his statement?
Officer Makuba's statement, Warrant Officer Makuba's statement?
Yes.
No, I'm not going to call him.
Thank you. Colonel Rolofsa?
I'm told my colleague that his statement by the end of this week will be ready, but they're not going to call him to testify viva voce.
It is not for them to decide. We will determine whether it will be appropriate for the witness to appear before us as a panel or not. You have to make an indication, maybe make a request to us. Counsel, is that you, Advocate Mayet?
Indeed, and I, just to inform the panel, Colonel Rulo, sir, we have consulted with him. His statement is ready. He, however, doesn't speak to 3.1. It is just background history about the investigation. But we will make the appropriate application to the panel.
Application to request that he should not give oral testimony?
Indeed.
Not even virtually?
In the event that the panel requires, it goes to 3.1.2. So it does depend on the extension of the amendment.
But we don't know. It may well be that we have other questions outside of 3.1.2 of the terms of reference.
Indeed, Judge. The statement will be ready, both of them, as well as number 9, Advocate Van Zyl. Both statements will be ready by the end of this week.
Would you please explain the delay? Why only at the end of this week?
Judge, this is my third week on this panel. So it has taken, I have consulted with both witnesses. The statements are 90% prepared. They simply just have to be finalized by being sent to the witnesses to review.
And Officer Brian Padayakshi?
On the aspect on which we wanted to call him, he says he is unable and he will not be called. I consulted with him, and he said he will not be able to help us. So he's out.
Outside of this list, did you have any other witnesses that you have identified?
I may mention, Madam Chair, that there is an officer who was with the late Superintendent Nkcukaitobi inside the vehicle when they were ambushed and fired at. And I was made to believe that is an important witness, and he has to be called. He's Superintendent Kanyile, who has deposed to a statement which is in the docket Maphumulo 99/8/2008, if I'm not wrong, the one which could not be traced, the one where the subs said they could not trace it. Now, we took steps to get Superintendent Kanyile's evidence before this tribunal. We wrote a letter through the state attorney.
Perhaps you can just tell us whether this witness is ready, and if he's ready, where is his statement?
Madam Chair, I'm getting to the point where I'm going to indicate to the panel that this witness has unfortunately passed on.
Yes.
And we're waiting for documents from subs in KwaZulu-Natal proving that he has passed on, among them the death certificate.
Any other witness?
I just wanted to put this across, Madam Chair.
Yes, we understand. Any other witness?
Before I proceed to
Outside the
another
list?
witness,
Yes.
can I put what I want to put across about Kanyile?
You may. You may, Counsel.
Kanyile Superintendent Kanyile has made a statement, and that statement is available. Now, we would approach this panel in terms of the provisions of the Civil Proceedings Evidence Act for leave from this panel to hand up this.
I request that you do that at that time. We're just trying to do housekeeping on the availability of your next witnesses, Advocate Motlamunyane.
Thank you, Madam Chair.
That which you are planning to do will happen at the time when you do that.
I thought I should put this across so that my learned colleagues should also know. I should not take them by surprise on the day on which I want to do that.
You can discuss these matters amongst yourselves.
Thank you, Madam Chair.
So on the list, as we tick the boxes, Officer Padayaki can be scratched, correct?
Correct, Madam Chair.
And who is next? Colonel Rolofse. Is he a potential witness? Yes, we can tick him to be available. And then Officer Makubo, not available. Correct, Advocate Motlamunyane?
That's correct, Madam Chair.
General Mukwanasi, not available.
Potential witness.
Is he a potential witness?
Yes, he is.
Advocate McAdam,
He's out.
General Boyson, potential witness.
Potential witness.
Advocate Riley,
Give me that. It's a potential witness.
now, yes, we have Advocate Van Zyl and Rolofse together. Yes, but they are tagged together. Am I correct that Advocate Mayet, that Advocate Rolofse and Advocate Van Zyl are in that category,
Indeed.
together with Advocate D. Barnett?
Indeed, Judge. I understand that Advocate Barnett is for the childcare team, but as evidence leaders, and we are obliged to assist the panel, and I have offered my learned friend that we have no problem calling him.
Yes, we see we have a number of advocates in this list, and I don't understand why it is difficult to get the statements of advocates. They can prepare their own statements. You are saying something, Advocate Ngcukaitobi? You can prepare their statements. They can prepare their statements and then pass them to you. And you can do a very short consultation to clarify issues with them. Why does it take so long for advocates to present their statements? I don't understand. Is there a problem?
There seems to be a problem, Madam Chair, which we don't know where it emanates from. One of the witnesses that I consulted was Advocate Beki Manyati, and I prepared his statement as well, very short statement. He testified in the Mokoro Commission, but he was not willing to testify at that stage. He said, let's first wait for Advocate Patohi's evidence to be finalized. So there seems to be problems that perhaps we are not aware of.
Now that we have spoken about this list, do you know whether Advocate Batohi is keen to come back?
We don't,
From
Madam
the
Chair.
application pending, she says she may come back, if she comes back. So we still don't know. Have you spoken to her?
No, we have not spoken to her, Madam Chair. We can only hope that she comes back. We thought we should perhaps wait for the application to be finalized.
But why so? Because you called this witness at the outset? I would have imagined that you would want to finish her evidence.
Because she's still under oath. We thought, because she's still under oath, let's perhaps not talk to her.
Yes, thank you.
A message here has just got in from the advocate on behalf of General Poison, who says, who confirms attendance of General Poison on the 8th of April. If it helps. What
Confirms what?
attendance of General Poison on the 8th of April.
Does he say anything about his statement?
Yeah, it doesn't help us. It says that the statement will be ready by the weekend. It doesn't help us. It doesn't help us really.
Shouldn't you find out as the evidence leader so that you can give us a definite indication about this witness, his statement, when it will be available?
Even early this morning, I wrote a note to say, please file a statement, but we'll do that, Madam Chair. We'll do that. And I'll get in touch with her to find out when the statement will be available.
Do you have a plan as to whom you are going to call if Major General Boyson does not come, or even if he comes, his statement comes late? Because we will not start this hearing without having read his statement. So you should be having Plan B, at least.
Plan B will be Advocate Riley.
When should we expect his statement?
Madam Chair, if I might come in, given the exigency of the matter, we'll try and also have it circulated at the latest over the weekend. It's not a long statement like Major General Poison's, and we'll also make arrangements that if she can't fly up here, then that necessary arrangements be made that she testifies virtually from Cape Town.
Who? Advocate Riley?
Advocate Riley, yes.
But if the statement is short, why can't we have it tomorrow?
Because I still need to send it to her for her inputs, but it mainly talks to the report. We'll do our best that at least by Friday, that it'll be filed by Friday. Or we'll just have to forfeit our trips to Moria and make sure that it's filed.
Well, we have tomorrow and Thursday, so you can file that statement by Thursday,
We'll do our
which
best.
is a working day.
Yes.
Friday is not a working day. Nobody's going to pick up that statement online. So if you can file Advocate Riley's statement by Thursday before the end of business so that it can be picked up by the secretary, then we can be alerted
We'll do so.
wherever we will be. It will also help Advocate Chauke's team also to access that statement and make copies, whatever they would want to do.
We'll do so, Madam Chair.
We are therefore placing you on terms to file their statement by Thursday, Advocate Mchene, please.
We'll do so, Madam Chair.
The next statement will be that of, because I'm trying to assist you in lining up your witnesses.
I believe it will be that of Van Zyl, Advocate Van Zyl, and Rulofsen.
When will that be filed of record?
Similarly, Madam Chair, I can undertake to have them ready by Thursday. I do so provisionally. The statements are ready, but they need to be signed, Madam Chair, but I will undertake my level best.
You can file them unsigned, and then you can file the signed one later,
Thank you for the indulgence.
so that you
Then
can have the statement.
Thursday,
As long as they're not going to be, the content is not going to be changed.
indeed. Thank you, Chair.
You will file those 3 statements,
Two, Madam Chair.
Colonel
Rudolph's-
Rolefse and Advocate Van Zyl.
Indeed.
The next statement, Advocate General Mukwanasi, when is it going to be filed? You said it's a short statement.
Yeah,
But, Mhlamunyane?
I still have to consult with him. I cannot make an undertaking at this stage. I was intending to do that immediately after I shall have led and finalized the evidence of General John Boysen.
You said it's a short statement. I thought that the draft is there.
There is a draft, but I still need to sit with him.
Can't you give us a tentative day when that statement will be filed? We're trying to get our house in order.
It's difficult for me to say so because I still have to have General Mukwanasi available. He should be available for my purposes to finalize the statement. And for the past 2 weeks, he was not available.
The next one in the list.
It's Molocha.
When will his
Advocate
statement
Molocha.
be ready?
It can be ready within a week, next week, before the end of next week.
Please give us the day.
Or no, before the 10th, Friday the 10th.
Might I request you, Counsel, that when you file the statements, do also file a list of documents that you are going to use so that we can have them all lined up behind us to avoid what happened today. At least you would know which part of the records you're going to focus on. Please prepare that. And for a very long statement, you'd have to give us a summary of the relevant part of those loan statements. You'd have consulted with witnesses, you know what the issues are. At least by now, we know what the real issues are. Then we can focus on the relevant issues. Should we therefore assume that on the 8th we'll start with either Major General Boyson or Advocate Riley?
Indeed, Madam Chair.
Advocate Mchweni is nodding. The recording machine won't see the nodding. But we accept, Council, that we will work on that basis. Anything else that you would like to bring to our attention? Advocate Ngcukaitobi?
Madam Chair, the only thing to say, it looks like the clearest witness that will be here on the 8th is Advocate Riley. If we could ask for that statement to be circulated on Thursday, and perhaps for the panel to actually make an order that it should be circulated on Thursday. Thank you, Madam Chair.
Well, I thought that I made an order, but I should expressly say so, that the evidence leaders are directed to file of record the statement of Advocate Riley by Thursday. What is the date? The second, this coming Thursday, before the end of business. Also, on the same day, the evidence leaders should file of record the statements of Colonel Roelofse and Advocate Van Zyl the same day before the end of business. We so order.
Thank you, Madam Chair.
As it pleases, Madam Chair.
We are going to adjourn until Wednesday, the 8th of April, 2026, to resume with the evidence of the witnesses for the evidence leaders. We would like to place on record also that the time allocated for the witnesses called by the evidence leaders will be the entire of April. We are going to adjourn until the 8th of April 2026. We wish you a safe Easter weekend. Those who are traveling, travel safely, and best wishes. Thank you.